29 is now in session. Honorable Judge Sarah B. Wallace presiding.
You may be seated. I was happy to have the camera on somebody other than me. Are the interviewers ready to present their witness?
Yes, Your Honor, we are. I understand a lot of the conversations. There are some evidentiary issues to discuss. I don't know if you want to discuss them now or wait until a little bit later today, Your Honor.
Do they have to do with Mr. Delahunty?
I believe they do not.
Your Honor, petitioners do have one issue related to Mr. Delahunty, just logistically, if I may, for a moment.
Sure.
I didn't want to interrupt the direct testimony with extensive objections to Mr. Delahunty, but we do have objections to both his qualifications and his methodology under Rule 702. And we also object to much of his testimony as purely legal opinion rather than history or other helpful expertise. And we were wondering if we could just get a standing objection on those questions during direct examination and then renew those objections and request a ruling after that portion of cross-examination.
Yeah, and probably most likely what I'll do is defer any 702 ruling until the findings of facts, conclusions of law that I'm going to be issuing. But I certainly want to allow you to make your record, but it's my intention to let Professor Delahunty testify.
Understood. I didn't want to disrupt the proceedings with repeated objections, but I also want to make sure that we've preserved it.
Yeah, no, so consider it reserved. And you're welcome to bring you a motion, 702 motion at the end of the proceedings today. But in all likelihood, I will just address that in conjunction with my final ruling.
Understood, Your Honor. And if I may, for petitioners today, Jason Murray, Eric Olson, Martha Tierney, Mikkel Suss, Mario Nicholas, and Sean Grimsley.
Okay. And why don't we start with an entry of appearance from the Colorado Republican Party? Well, then.
Good morning, Your Honor. Jane Raskin on behalf of the Republican State Central Committee with me are Michael Melito, Nathan Holker, Bob Kitzmiller.
And why don't we take care of the respondents, and then you can introduce people until they all the other issues you need to deal with.
Good morning, Your Honor. Michael Kolarczyk from the Attorney General's Office on behalf of the respondent, Jenna Griswold, Secretary of State in her official capacity. With me at council table is Jennifer Sullivan from the Attorney General's Office and Deputy Secretary of State Christopher Beal.
Great, thank you.
Thank you.
Mr. Hester.
Good morning, Your Honor. Staff Hester on behalf of President Trump. With me is Mr. Chris Alwan. I don't know if his copy Jake has been finished.
It has been.
It has been, so I don't expect him to talk, but he may. Mr. Jeff Blue as well, Mr. Jake Roth, and Mr. Justin Mills.
And you had an evidentiary issue you wanted to address?
I don't think I'm going to press it on a little bit. I would refer to Mr. Blue. These other conversations with Mr. I think this has to just go ahead and just press it off, and then we'll do these housekeeping items at the end of the day.
Okay. Okay, we need to take a pause while the court reporter deals with some technical issues. I know, Mr. Gessler, that you could appreciate technical issues.
I can truly empathize.
You don't think I should blame Mr. Gessler for that, Mr. Blair? You don't think I should blame Mr. Gessler for the technical issues?
I try to take responsibility for myself.
Your Honor, while we're doing this, I think you had mentioned that the Denver guest Wi-Fi was not a good Wi-Fi for us. Is there another network we can use?
No,
Okay.
I just meant that if you bring your own, it usually works better than the guest Wi-Fi. cases is that I think take it a little longer than the court reporter hoped, rather than having everybody sit in silence, staring at her, putting more pressure on her. I'm going to go off the record, and we'll come back when she's got it taken care of.
Okay.
Not like mine.
No, you don't use that mic here.
I would freaking hate it. I also think I should reboot my computer anyway.
Yeah.
So from now on, before I fresh, I will turn my computer off, and not even just reboot it. Turn it off, and just have it. And then bring it back.
When I had come up like on the stand, I was switching line, and there would be a little delay, and I was trying to wait for a moment to like push the button and switch over. And, you know. But then, yeah, she saw it like, oh.
Reality, because I don't really need to be on the video for this. The lawyer doesn't
You have the camera, so yeah. So it is. You're right. It's
It's not very flattering. No, it's not. It's not my best time.
and then if you move around, it's usually catching like here or here.
And of course, and of course, the way I stand up there.
So then you're and there's like when they run theirs, you know, then you're back and forth, you know, it's catching the ear.
That's channel 7. Maybe that's what it's saying. We got plenty of time. We're not in a rush.
Oh, did you? Oh, did you? I didn't see it. There's an extra top and roll that nice little zip up.
You know what?
Be seated. Let's proceed.
Thank you, Your Honor. For our next witness, we would call Mr. Robert Delahunty.
Will you raise your hand? Do you solemnly swear under the penalty of perjury that the testimony you will give this court is the truth, the whole truth, and nothing but the truth? Great. Have a seat and just make sure to speak into the microphone.
Good morning, Mr. Delahunty. So, I'm going to be asking you some questions today, and you're here. We've called you as an expert. Let me ask you: have you ever testified? Let me start with this. Could you please state and spell your name?
Yes, Robert Delahunty, Delahunty.
Okay. And Mr. Delahunty, have you ever testified in court as an expert before?
No.
Okay. So this is your first time.
It is.
So let me start with asking you a little bit about your professional background. What's your current position, if any?
I'm retired.
Okay. As someone who's retired, are you involved in any law-related activities?
Well, I write articles for other court pieces on law and public policy.
Oh.
And in June, late June, a book which I co-authored, a semi-popular book, was published. It's called The Politically Incorrect Guide to the Supreme Court. So that reflects the writing that I have done
Okay.
quite recently.
Professor Delahunty, you're leaning back.
Oh, I'm so sorry.
Just maybe far from the microphone. So
Okay, try to get closer. Thank you.
you may be able to move the microphone too, but just make sure you speak.
Can you hear now?
Yeah.
Thank you.
Okay. Yeah, Professor Delahunty, sometimes it's a challenge whether you're supposed to answer me or look at the court when you're speaking. But since there's a fair amount of media coverage, just try and stay close to that microphone. Let me ask you to start with your legal background in chronological order. What's your education?
Well, I graduated in 1968 from Columbia University and had a summa cum laude degree there. I then won a Kellogg Fellowship from Columbia to study at Oxford University, England. I studied a subject called race, which consists of two parts, classical history and classical and modern philosophy. And I got a first-class honors in race. I then did a second degree at Oxford University, Bachelor of Philosophy. I wrote a thesis on Aristotle. I then had a career in Britain, both at Oxford and Durham University, teaching philosophy. I was tenured at Durham University as what they call lecturer on philosophy faculty. That was the equivalent really of an associate professor in the United States. At that point, about 1980, I decided to return to this country and to study law. And I studied law at Harvard Law School and graduated cum laude from there. And then this is not educational background, but I passed. I spent 3 years on Wall Street at a law firm called Sullivan & Cromwell, and then I joined the Department of Justice, the appellate section of the Civil Rights Division in 1986, and then at the start of 1989, the start of the first George H.W. Bush administration, William Barr, later twice Attorney General, invited me to become a staff attorney at the Office of Legal Counsel in the Department of Justice, and so I began working there in early 1989. I don't remember the year, but I was eventually promoted to the Senior Executive Service in the Department of Justice. And from 1989 until 2004, I served primarily in the Office of Legal Counsel, although for about a year, I was the special counsel to the Solicitor of the Department of Labor, the U.S. Department of Labor, the Independent College, Red Line, England. And then I served, I was on unpaid leave of absence, but still employed by LLC for a year. To be a visiting professor at the Columbus School of Law in Washington, D.C., which is part of the Catholic University of America. And while at St. Thomas, I was there from 2004 until the end of 2020. At the end of 2020, I retired, and now I am a fellow for the Claremont Institute Center for the American Way of Life in Washington, D.C., and do give them legal advice from time to time. I published an article in a book, a collection of essays they put together, that also came out.
Okay.
In June.
Let me interrupt you for one moment. So,
I think the court reporter probably needs a breath. Because that was a crazy long answer. So it's just, I think it helps everybody if you let him kind of guide you through your testimony.
may I offer that it was also an erudite long answer, Your Honor? Okay. Let me ask you a little bit about your time. You said you worked at St. Thomas School of Law from 2004 to 2020. What did you do there?
I taught constitutional law in every year I was there. I'm not absolutely certain that I did not teach it in the year I was on, half year I was on sabbatical, but constitutional law, including, of course, the 14th Amendment, that in fact was the centerpiece of my teaching. And I taught public international law, and one term I gave a seminar on the law of genocide, which is international law.
Okay. During your time in any of these positions, and it looks as though you spent most of your, or a large portion of your career, large chunks, at both the Office of Legal Counsel at the Department of Justice as well as St. Thomas School of Law. Did you have an opportunity to work with historical documents?
Oh, yes, indeed.
Can you describe some of that?
Well, I could go on, I hope not too much, but let me give you three examples. One of the first assignments I had in the appellate section of the Civil Rights Division of Justice, this was in about 1986, was to do research into the Civil Rights Act of 1866, which is now codified as a section. It's sorry, I'm blanking on the site, Section 1981 of Title 42 of the U.S. Code. And that involved research, including looking at dictionary definitions from the 19th century on the meaning of the term race. That was in connection with an amicus brief that the government eventually did not file in a case called Charlie DeFillo versus Cobb. So my whole research led me to draft an amicus brief for the government that was never filed, but it did, right at the start of my career in the Justice Department, entail research into private documents and into the background of the Civil Rights Act of 1866.
Okay.
More recently,
I was about to ask you for your second example.
yeah, this is a law review article I published 3 or 4 years ago, maybe 4 or 5 years ago. I'm interested in the law in Shakespeare, and so I wrote a lengthy article about the law in his play King John. This entailed research into the English law of intestacy and bastardy in Shakespeare's period, the Tudor period and the Stuart period. And I made quite extensive use of a database compiled by the University of Michigan, which is called Early English Books Online. It is a collection of thousands of legal and other documents, proclamations, sermons, books of the Tudor and Stuart periods. And so I did that kind of research into English legal history of the early modern period, and in the Middle Ages, because the play is set in the Middle Ages, on the law of intestacy and the law of legitimacy, using those historical materials which are archived at the University of Michigan. And if I'm
Then-
another example.
Yeah, let's do one more example and then we'll move on.
Some years ago, in the Cornell Law Quarterly, Law Journal, I published an article on Declaration of War Clause of Article 1 of the Constitution, and I did primary research, or research relative to primary materials from English law, English legal cases, I think it was prize law, from the middle of the 18th century, consulting the original case materials.
Okay. Have you written any pieces or articles involving the vice president in the electoral count?
Yes, in 2022, along with my orphan co-author, Don Liu, who is a chair professor of law at the University of California at Berkeley, and we published an article on the 12th Amendment and as we understood it, the constitutional authority of Congress to regulate the vote count process and in presidential elections, and on the constitutional role of the vice president in the vote count of the electors, potential electors' votes. Incidentally, I also involved research into materials from the earlier one.
Okay. Now, Your Honor, to be frank here, we had prepared to provide extensive testimony on Mr. Delahunty's background, but in light of your earlier ruling and to keep the proceedings moving, at this point I would proffer Mr. Delahunty as an expert in the use of historical documents, legal historical documents and interpretation of legal statutes arising from that historical analysis on constitutional issues.
And Your Honor, we would ask you defer a ruling until we have a chance to explore those subjects on cross.
I'm gonna accept Professor Delahunty on what sounds to me is a very specific subject, which is the use of historical documents and interpretation of legal statutes arising from historical analysis on constitutional issues. He was a law professor for 16 years and had a lengthy career before then. And obviously you can cross-examine him, and I will consider that in the wake of his testimony. But at the same time, Mr. Professor, I don't want to short-circuit your examination in any way, so you should feel free to ask him whatever you want to ask him for the record.
Thank you, Your Honor. Your Honor, I would like to clarify legal interpretation of statutes as well as constitutional provisions.
Okay, I was reading from what you said.
That's why I clarified, Your Honor.
But I will expand it to statutes and constitutional provisions.
I'm accepting responsibility for the lack of clarity. And Your Honor, I would also note that we specifically proffered Mr. Delahunty as a rebuttal expert to Professor Magliocca as well. And so he'll directly address the items raised in Professor Magliocca's testimony.
Okay, well, Professor Magliocca, if I recall, was offered as an expert on on Amendment 14, and specifically Section 3. I'm not prepared at this point to designate Professor Delahunty as an expert on that specific provision, but I can ask you to either.
Okay. Well, Your Honor, we would then seek to proffer him as an expert on the 14th Amendment, as he taught constitutional law for 16 years. On the 14th, taught constitutional law for 16 years with a specific focus on the 14th Amendment.
Can you hear a little bit more from him on what he meant when he said that? most of the people, it seems like in the group who went to law school, my recollection of constitutional law was that it covered a lot more than just the 14th Amendment. So let's find out what he meant when he said that.
Okay. And Your Honor, I would also note that we, to be straightforward with the court, we obviously raised a 702 objection to Professor Magliocca, and our view is that all of this, Professor Magliocca's testimony and Professor Delahunty's, is akin to legal analysis and interpretation, which normally tends to be excluded by courts. And we understand that it's here to help you, and we understand also that you noted that you recognize that there are a number of other published professors in the field that you will look to as well. So.
And just on that, and maybe this will help you focus on Professor Delahunty's testimony. Professor Magliocca largely talked about historical interpretation. I did not think, I'm not sure if maybe not if all he testified as to the law. He testified as to the original documents that he uncovered in looking at the formation and the purpose of the amendment in the first place, and that is what I found helpful.
Okay. And I think you will hear from Professor Delahunty the interpretation of original documents as well.
Great, thank you.
Okay.
So why don't we just defer? I think it would be helpful for the court if you could explore further with Professor Delahunty on exactly what work he did on the 14th Amendment and if any of that focused on Section 3.
Okay. Professor Delahunty, you've said you taught law school for, I believe, 16 years at St. Thomas, and that a substantial focus of your teachings was on the 14th Amendment. Could you provide some more detail on that?
Yes, indeed. I think that half of the course consisted of a study of the 14th Amendment. I was, I think, quite unusual among American law professors in starting the course with the 14th Amendment, and that took over half of the term. Then I gave attention primarily to separation of powers in the final, let's say, 40% of the course. And I focused on the 14th Amendment because I agree with the view that it was a second family, constitutionally speaking, and it was also the focus of a lot of contemporary discussion and litigation, and I wanted to make sure my students were quite well aware of what it meant, what its origins were. I think, again, pretty unusual among American constitutional law teachers in discussing some depth, actually, the Dred Scott case and its background to the ratification of the 14th Amendment and how parts of Section 1 of that amendment were framed against the backdrop in connection to the Dred Scott decision. Most constitutional lawyers, I think, don't discuss the Dred Scott case.
And why did you focus? Well, what is the Dred Scott case, and why did you focus on that?
The relevant part of the opinion of Chief Justice Trump in that case was that African Americans, including those who were not African, were not and never could be citizens of the United States, and the naturalization provision of the citizenship provision, rather, of Section 1 ensures that they all were citizens of the United States, entitled to the privileges or immunities of citizens of the United States. So it helped to explicate the meaning of those parts, especially of Section 1. I told the story of that case every year. And so I'm not just focusing on the history of the framing and ratification of the 14th Amendment, but both the case law, Supreme Court case law, before it and after.
Did you also, as part of your course, introduce or teach your students how to view and interpret and analyze historical documents?
Well, the Slaughterhouse case itself is a historical document, as is the Dred Scott case, so yes, in that sense, yes. But this was not a course in legal history. It was a course in constitutional laws, and it wasn't a course in historical scholarship generally, or even in legal historical scholarship. It was a course mainly dedicated to explicating the meaning of the 14th Amendment.
Okay. And did you introduce some elements of historical legal scholarship to your students, and I'll ask you the next question after that.
Not that I recall, no.
Okay. In preparing your courses, did you engage in historical scholarship, looking at some of the history of documents surrounding the formation and ratification of the 14th Amendment?
Well, I think only to the extent that I really explained.
Okay.
I did not, that I recall, drill into the ratification or framing of the 14th Amendment. No.
Okay.
This was a first year law student course.
I'm sorry, what was I?
This was a course for first year law students, and did not go into. I mean, I discussed the Civil Rights Act of 1866. I don't know if that would count in answering you or not, but yes.
Okay. Your Honor, I would renew my proffer. Does that answer your questions?
Your Honor, we would continue to object. Teaching a first-year law school course does not mean that he's made contributions to scholarly literature on the history of the 14th Amendment, Section 3 in particular.
Your Honor, if I may, we're going to go through his resume at length this morning, so this may be a while.
Yeah.
This may be a long morning, but we'll do it. Professor Delahunty, I saw that one of your articles is the Uniform Faithful Presidential Elector Act Constitutional. Do you remember that article?
Can you tell me where you read it?
It was Cardozo Law School online publication in 2016.
Yes, I remember that.
Okay. Can you tell us about your work on that particular case,
Well,
or that particular article? I'm sorry.
The article involved going into the meaning of what counted as an elector in the framing of the original Constitution, and whether electors, as understood at that period in 1787, were considered to be people who had such unfettered freedom to decide whom to vote for as a leading figure in the state. So, for example, I found that the King of England was an elector for the Emperor of the Holy Roman Empire, and Breakers, as subjects of the King of England before the American Revolution, were probably aware of the King's role as an elector. He was not just the King of England, he was the King of Hanover in Germany, and as such he counted as an elector for the Empire. My conclusion broadly was that presidential electors in this country had the freedom to vote for a candidate whom they were not pledged to support. In other words, that they were not bound by state restrictions on their ability as presidential electors to select a candidate who best suited, who in their judgment was best suited to be president. That view, which was based on original materials, was rejected by the U.S. Supreme Court in Chaffa case, which upheld the binding quality of the pledges electors made to vote in a certain way, but it was an attempt to clarify, using contemporary dictionaries and so forth, the meaning of what an elector was in the electoral colleges.
Okay. I saw that you also wrote an article on who counts, the 12th Amendment, and the Vice President, and the Electoral Count. I think we've spoken a little bit about that. Can you tell me what that was about, and use, if any, of historical documents and scholarship?
Well, there was extensive use of historical materials, both from the framing period, 1787, and much later, and it wasn't just documents, it was historical practice, such as the role the Vice President had played in the electoral vote count when John Adams was in the chair, and had been George Washington's Vice President, and then Thomas Jefferson's Vice President also oversaw the electoral vote count. They both assumed they had authority to admit or reject.
Okay.
Continued votes.
Okay. You also wrote an article, it looks back in 2006, entitled Executive Power versus International Law. Can you tell me a little bit about that?
Honestly, I don't remember that one. It was, it's just a tradition, I think they're well seen, I'm certainly steeped in that culture, a defense of presidential power, executive power in wartime. It's been a while since I looked at that. I think, however, it made a reference to the Price cases, which is one of the cases that's helpful in construing Section 3 of the 14th Amendment.
Okay. Let me ask you this. In your work, have you, well, let me, before I go there, you said you spent time in the Office of Legal Counsel, correct?
Yes.
What were your duties or activities there?
Essentially preparing legal opinions primarily on constitutional law and reviewing bills before Congress to determine whether to review the executive branch. The bills included unconstitutional provisions.
Okay. Did you have an opportunity to work with historical documents in those instances?
Yes.
Can describe what that, an example, or what that process might look like?
Well, I remember one tragic weekend when I had to write an opinion on the constitutional validity of President Clinton's appointment of a member of Congress to be our first ambassador to Vietnam since the war in Vietnam ended, and that involved looking at historical practice and discovering back, as I recollect, at least as far as James Madison.
Okay.
But it was, as I say, the lead indicators of OLC to, and I worked for, to apply on constitutional questions across the board.
Okay. In your work, have you spent time looking at and analyzing records of congressional proceedings?
Yes.
Okay. So are you familiar with the congressional reporters as they were developed then?
Yes.
Okay. In your work, have you spent time, and if you can describe this, working with historical legal opinions?
Okay.
Have you spent time working with sort of the congressional debate issues and historical legal cases from the 19th century? Can you speak up to this? Okay. Have you spent time over your years of experience working with contemporaneous reports on congressional and public debates involving constitutional issues?
Yes.
Okay. I think you testified, but I want to confirm, have you spent time analyzing and researching and reviewing historical definitions of words and phrases?
Oh, yes.
Have you spent time looking at sort of historical executive orders and statements as an aid to interpretation of law?
Yes.
Okay. Now, you reviewed, if I correct, the congressional debates, or records of congressional debates, historical cases, contemporaneous debates, dictionary definitions, and executive orders in rendering your opinion on the Section 3 of the 14th Amendment. Is that correct?
I'm sorry, could you repeat that?
That was a very long question. In preparing and rendering your opinion today, did you rely on records of congressional debates?
Yes.
Okay. And do the records of congressional debates for Amendment 14, Section 3, do they differ in an approach or quality or in any way that you may be able to describe from congressional records used to interpret other constitutional provisions?
No, not that I see. Maybe there are fewer, less discussion of Section 3 than some other provisions, but no, in quality, maybe quantity is less, but in quality, they're the same.
They were written in the English language as used in the 19th century.
You need to wait for Mr. Kessler to finish his question before you start answering, because the court reporter can.
Oh, I'm sorry.
Yes, in court we have to be exceptionally polite and never talk over one another, or to the best of our ability.
I apologize.
So in your experience, were they sort of written in the same English language syntax as other forms of 19th century documents?
Yes.
He's just laying the
Thank
foundation.
you. And you've discussed I'll even try to be a little bit more open-ended, Your Honor. You've discussed your research of legal cases, historical legal cases. How do those compare with the legal cases that you reviewed and analyzed in preparation of your opinion here today on the 14th Amendment? I'm sorry, you say no way. How do they differ, if at all?
Again, I'm going to have to ask because we repeat.
No problem. So you reviewed you have in your work over this last 4 decades, interpreted historical cases from the 19th century. Is that correct?
Yes.
Do the historical cases that you reviewed for the 14th Amendment, in your opinion, do they differ, or how do they differ as far as and any characteristics, as their writing, their modes of analysis, do they differ, and if so, how, from the types of cases that you've analyzed in the past from the 19th century? When you say no, does that mean you were not able to identify any types of differences? Okay. In looking at reports involving sort of public reports, or what we would today call media reports, newspaper reports of congressional and public debates from the 19th century, did those differ in any manner, and if so, describe it, from the types of documents involving public and congressional debates that you reviewed for your opinion?
Well, I don't immediately recall reading newspaper articles from the 19th century, but if they were reports of cases, no, they would be equivalent to the case reported now.
Okay. And have you had experience reviewing or dictionary definitions from the period of the 1860s and 1870s in your work?
Well, the case I can recall where I did that was research on the background of for our potential filing of the news brief in Shari to fill versus Collins.
Okay. So
I also looked at 18th century dictionaries of the English language, like Dr. Samuel Johnson's. I think I did that in preparation for the research I did for the piece on the Electoral College and the rights of electors to decide independently. So I think I used Samuel Johnson's dictionary of the English language, which was 18th century, in connection with research for that article in Cordova.
So your review of, so did you review dictionary definitions for the opinion that you rendered on the 14th Amendment, Section 3?
Objection, Your Honor. No such dictionary definitions are disclosed in the case report.
There is a reference to,
Your Honor, he was in general viewed as a rebuttal expert to Mr. Magliocca, and to the extent Professor Magliocca relied upon those, we've had Professor Delahunty review Magliocca's testimony, as he's allowed to do, and to render an opinion on that. We're not looking to go substantially outside of Professor Magliocca's report, and nor are we looking to go outside Professor Delahunty's report. If there's an objection specifically to opinions, but we believe that within his report he did mention various definitions. To the extent there's an objection about a specific, we're certainly willing to take that up. But as a general matter, the point is that Professor Delahunty has reviewed dictionary definitions contemporaneous similar to any ones in this case.
I'm not allowed to testify about the dictionary definitions that Professor Magliocca testified about.
Okay.
If he's talking about different dictionary definitions from the 19th century that haven't been disclosed, that's another story.
And that's fair, Your Honor. Okay.
So objection overruled. Okay, that's not normal, but what's your question?
well, I think a lot of hinges on what we mean exactly by the dictionary.
So, Professor Delahunty, why don't I ask you a few of those questions, and feel free to ask me. We'll clear it up. So, in rendering your opinion, you, I think both you and Professor Magliocca discussed a executive order, or executive statement, I should say, from President Grant.
Yes.
And I want to be a little more concrete here. In reviewing that executive statement, did that differ from the types of executive orders or executive statements that you've reviewed in the past and worked with from that period of history?
No.
Your Honor, I would renew my proffer.
Yeah, I'm not sure he's already been endorsed as an expert in constitutional law and the application of historical documents to 19th century statute and constitutional provisions. So I'm not sure he needs to be designated as an expert on Section 3 because I'm going to let him testify about what he did regarding Section 3. I don't think that, unlike Professor Magliocca, who is clearly, spent years studying it and is an expert on Section 3, I don't think he is, but I don't think it matters because what he's done is he's looked at historical documents, which he is an expert in, and he's going to hopefully testify as to what his findings were using that expertise regarding Section 3.
Your Honor, we endorse that perspective. I don't know if I can ask to have it admitted to evidence, but we endorse it, Your Honor. Okay, let's talk about the substance of your opinion, Professor. Did you listen to or review Professor Magliocca's expert testimony on Wednesday?
I did. Okay. The last testimony, yes, I have both watched it and read the preliminary transcript of it.
Okay.
In fact, I read his reports there too. I've read them very closely and several times.
Okay, and so are you prepared to respond to or comment on his analysis? Okay. Let's start as a general matter. He testified that Section 3 of the 14th Amendment is not limited to the events of the Civil War. What do you think of that statement?
I do agree with that. I think there are scholars who might dispute that, but after, frankly, it was when this issue of Section 3 began to come up, my view was how can that possibly be? It's clearly confined to the Civil War, but as I delved more closely into the matter, I think the very is that it's not time-bound in that way. It's not restricted to the events of the Civil War or to the people involved in the Civil War, and I think there are three reasons in support of that. One is that the text itself of Section 3 does not, in express terms, limit its application to the Civil War. Second, there is some highly relevant congressional testimony by the framers of Section 3 that it was meant to extend into the future. And third, the practice, or limited, has been to extend it, apply it to events involving people who have no role in the Civil War.
Okay.
Can we just take a slight pause? I want to talk to the court reporter for a second.
Okay. Do you want us to take a 5-minute break, Your Honor, or just? Okay.
I'll just try to get reconnected to the real time, so that kind of helps me to make sure that I'm following what the professor's saying.
You want to trust me, Clara?
No, I'm not sure if it's a volume or if it's just your mannerism of speaking. I'm having a little bit of trouble following you, and I also lost the transcript, so I was hoping to get the transcript back. But if not, we'll just proceed. Nobody's connected. Well, we'll just deal with it on break then. Sorry for the interruption.
No problem, Your Honor. Are we prepared to go forward?
Yes.
Okay. So, Professor Delahunty, I want to talk a little bit. We're just going to dive into some of the main subjects here. I want to talk about the definition of insurrection. And Professor Magliocca provided a very specific definition of insurrection and looked at historical documents like insurrection examples of events and judicial decisions and the treatment of the law during the Civil War. What's your review of those documents tell you about the definition of insurrection?
Some of the materials that he offered are quite broad definitions of insurrection. So others narrow ones, so they differ. In particular, he cites the definition of insurrection that is offered was drafted by Professor Francis Lieber, who was one of President Abraham Lincoln's chief legal advisors during the Civil War. Lieber's definition of insurrection appears in Lincoln's General Order Number 100 to the Union Army. And Professor Magliocco says that Lieber was, I don't have this transcript before, but in effect, the leading legal scholar of his period. And Lieber actually called it Columbia, which I'm proud of. And in General Orders Number 1, which I have studied and told about for quite a while, Lieber says, I don't have the text right in front of me, but he says, in fact, an insurrection is a rising of people in arms. So if you accept Lieber's definition as definitive, or at least very weighty evidence of the meaning of insurrection, an insurrection would have to be in arms. Insurrectionists would have to use arms. And that's, I think, inconsistent with many, if not all, but anyway, many of the other definitions, including the case law that Professor Magliocco cites. But, so there's some contradictions, perhaps in some word, tension between the accounts of insurrection that some of the sources supply, which don't require that the insurrectionists be armed, and Lieber's definition.
Okay. Professor Magliocco also cited to Webster Dictionary definition of insurrection in 1828. Do you remember that?
I remember that precisely, yes, and I read the quotation, yes.
Okay. And I'll quote you that it said, rising against a civil or political authority, the open or active opposition of a number of persons to the execution of a law in a city or state. And then he also cited to a John Bogue dictionary definition of insurrection as being identical to the Webster definition. What do you make of that interpretation? What's your interpretation?
Well, the Webster definition specifically refers, as you quoted, to states and counties. Obviously, it's high competent evidence about the meaning of insurrection by Section 3, but it's by no means identical, because insurrection, as used in Section 3, must be against the Constitution of the United States. The United States is a specific country. Is not, oh, I'm sorry, is not a state of country.
And what's the when you say insurrection against the Constitution of the United States? What's the importance of that distinction?
I think that is really crucial because while it is very helpful to know what insurrection was understood to mean, or likely understood to mean from 1866 to 1868, while that's very, very useful, Professor Magliocco himself emphasizes that there is this important limiting principle which is found in the text of Section 3. It's not just a plain vanilla insurrection, it's an insurrection against the Constitution of the United States. And that's in the text, and it is a critical element of the offensive issue, that the insurrection be an insurrection against the Constitution of the United States. In other words, insurrection is not a freestanding term in Section 3. It's coupled with, Professor Magliocco's own insistence, really, it's coupled with that other phrase, insurrection against the Constitution. So what really needs to be expurgated and decided is not the sort of plain vanilla, as I called it, meaning of insurrection, but the whole phrase, insurrection against the Constitution of the United States. There's no, to my knowledge, any dictionary definition or definition of a legal dictionary of that phrase.
Okay. Professor Magliocco also testified that before 1862 there was no federal crime of insurrection, and that the cases that discussed insurrection were really treason cases. And so, for example, he cited a grand jury charge from the U.S. Circuit Court in Missouri from 1861, which specifically said the conspiracy and the insurrection connected with it must be to affect something of a public nature concerning the U.S., and that included, quote, overthrowing the government or to nullify and totally hinder the execution of some U.S. law or the U.S. Constitution or some part thereof, or to compel its abrogation, repeal, modification, or change by resort to violence. What's your view on the use of that grand jury charge and the importance of that, or lack of importance, with respect to defining insurrection?
I'm going to object again. They've had Professor Magliocco's report in this case for about a month before they submitted the rebuttal report in this case, and the rebuttal report in this case did not discuss any of these sources.
I'm going to overrule the objection. I am going to ask Mr. Kessler when you read from...
Be slower?
Be slower for the court report.
I just got that. Right. I'm sorry, Your Honor. I'll calm down and more complete slower. My apologies.
You're both offending me. You both are not understand. And hard to report for the court reporter.
I think it's just the slowness of the internet connection, Your Honor. No, I'm sorry. I'll work on that, Your Honor.
I think you probably need to repeat the question.
So, Professor Delahunty, I gave you a very long quote from a grand jury charge from Missouri. Do you need me to repeat that, or are you able to?
I'm familiar with Justice Catherine's discussion of insurrection.
So it says the conspiracy and the insurrection connected with it must be to affect something of a public nature, and it included overthrowing the government to nullify and totally hinder the execution of a law, constitution, some part of it, or to compel its abrogation, repeal, modification, or change by a resort to violence. What do you think of that use of that sort of historical document?
I think it's relevant to discussing the meaning of insurrection as understood, as that term was understood in the immediate run-up to the Civil War. It is helpful in that connection, especially because it comes not from the state court or lower federal court, but from the justice of the U.S. Supreme Court.
And how does that definition compare with other definitions that Professor Magliocca testified to?
Well, I can't remember in detail the other definitions. They're framing the phrasing. He says that it's relevant to understand Section 3. It is. And is it consistent with other definitions from roughly the middle of the late 19th century? I think it's certainly not in contradiction with any step Lieber. But no, it's not even in contradiction with Lieber because I think at the very end he talks about violence.
So, is it a more sweeping definition than some of the other definitions that you review?
Probably.
Okay.
I mean, it's something of a public nature is pretty broad.
Okay. Professor Magliocca also discussed the Whiskey and Freeze rebellions as insurrections. How do they relate, in your view, to the interpretation of the meaning insurrection against the Constitution?
Well, Professor Magliocca says that they are not the kind of insurrection that is covered by Section 3. And whether that's true or not depends on how you interpret against the Constitution in Section 3. He offers his own interpretation. It's not dictionary definitions. It's his interpretation of what insurrection against the Constitution means. And he says under his interpretation of that constitutional clause, the Whiskey and Freeze rebellions are not insurrections against the Constitution of the United States. I think that depends on the meaning of insurrection against the United States. And there could be a broad or narrow reading of that constitutional language under which both insurrections were against the Constitution of the United States.
And what would that reading be?
So Professor Magliocca offers this interpretation that an insurrection against the Constitution of the United States is an insurrection that interferes with the execution of the Constitution. And then the question becomes, well, what is the execution of the Constitution? And in substance, as I understand it, he's saying the execution of the Constitution is interference with the federal government's political branches and judicial branches' performance of their constitutionally appointed functions, if it interferes with the discharge of their constitutional responsibilities. And he argues that certainly the events of January the 6th are an interference with the congressional duties assigned by the 12th Amendment to observe the vote count. Now, on that definition of interfering with the execution of the Constitution, it seems to me that there could be many other events that were similarly insurrections against the Constitution, even in the sense of executing the Constitution. For example, if there is an interference with the execution of the judicial function of adjudicating cases, clearly the responsibility of the federal judiciary under Article 3, if you interfere with the execution of the constitutionally appointed judicial responsibilities, that would also, by burning down the courthouse or disrupting judicial proceedings, that would also, I guess, under that understanding against the Constitution, the insurrection against the Constitution or against the execution of the Constitution. Or take another case, the Constitution assigns to the Senate the lead role of debating and deciding on presidential nominations to principal offices in the United States, so the state appointments to the federal judiciary. If you have a crowd disrupting the Senate's vote on a presidential nomination, that would seem to be an interference with the execution of the Constitution. In fact, you could, I think myself, under that definition of interfering with the execution of the Constitution, that even disrupting the delivery of the mail, which is the issue in the Supreme Court's decision in the Death case, would count as interference with the execution of the Constitution because the President has the constitutional duty to ensure that federal law is faithfully executed. So we're interfering with the President's execution of his constitutional duty to execute the postal law.
And why do you say the Postal Service?
Well, because Article 1 mentions the Postal Service, and it's apparently, as Ted understands it, a duty of Congress to execute that power and to create and instruct the President to administer the statute regarding the Post Office. So, to cut it to the chase, basically, I think that under even Professor Maglioka's interpretation of against the Constitution, disrupting the delivery of the mail is interference with the execution of the Constitution. And you could go on and on with examples of interference with the execution of their responsibilities by the President, by the Senate, by the House, by the courts. That would count as against the Constitution, as he understands that. So what is meant to be a limiting principle is, I think, a very expensive one, unless you attach a more limited scope to the meaning of against the Constitution. What I think is his understanding. It does cover what he denounces, the whiskey insurrection and the police insurrection.
So that definition also includes intimidation, correct? Or are there sources that talk about mere intimidation as the necessary threat of violence for insurrection?
So I don't really understand the question.
Okay, let me move to a slightly different area.
I'm going to ask you a question. So, as I understand it, what you're saying is that if you take Professor Maglioka's interpretation of what insurrection is sympathetic and just applied to the need of different things.
Yes. Really, almost all of the interferences with the execution of the duties of the President, the Senate, the House, and the federal judiciary. It is a limit.
I assume we'll get to what he thinks what he thinks it should be.
To the extent that's possible, yes, Your Honor, from the texts. Let me ask you this. Professor Maglioka also testified that the shall have engaged in insurrection or rebellion language means any voluntary act in furtherance of an insurrection against the Constitution, including words of incitement. And he based this on judicial decisions and a U.S. Attorney General opinion of Attorney General Stansbury. What's your opinion on that, on the use of Stansbury's opinion in defining what insurrection is?
I would have three thoughts, I guess, about that part of Professor Maglioka's testimony and report. First of all, I would say it's a linguistic one. I think engage in insurrection has a more restricted meaning than he supposes. Let me give you this. Speakers of the English language, I think this. If we use a phrase like engage in hostilities, we probably have in mind combat, not the preparatory actions that would go with engaging in hostilities. I think intuitively we would distinguish engaging in hostilities from engaging in incitement, let's say, to hostilities. So that's just a linguistic point. But the backdrop to the Constitution's Section 3's use of engaging in insurrection, part of it is the Second Confiscation Act, which I think Professor Maglioka cites, which itself distinguishes between various preparatory or accompaniments of engaging in insurrection and engaging itself. That's the language of the Second Confiscation Act. And so the Act distinguishes between, let's say, inciting an insurrection or rebellion versus engaging. Congress had that template before it and cut out, or at least didn't include, all this other language. And in Section 3, it narrows it to engaging in insurrection or rebellion, which I think very strongly suggests that it was not covering the same class of activities as the Second Confiscation. So engaging in insurrection in Section 3 has a narrower meaning than the comprehensive, sweeping account of the activities associated with insurrection or rebellion. See, listed enumerated in the Second Confiscation Act. I agree with Professor Maglioka that Attorney General Stansbury's two interpretations of statutes, the use of in the Military Reconstruction Acts of 1867. I agree with him that the Attorney General's opinions are certainly good evidence as to the meaning of engaging in insurrection in Section 3. They were opinions that were written while Section 3 was being debated and in the process of ratification. He actually, Stanbury actually has a section in the first of his opinions dealing with the statutory language of what it means to engage in insurrection. So that's the difference is from high officer of the executive branch. It is about a statute, but it sheds light on what engaging in insurrection means for Section 2 purposes.
And looking at the Stanbury opinions, what's your view on how he defined insurrection and its application to Amendment 14, Section 3?
So I think Professor Magnotta under-describes what Attorney General Stanbury is writing about. When in the first of these two opinions on the Military Reconstruction Act, in the first of them, Stanbury has a section called something like engaging in insurrection. Well, I think it's actually called engaging. It's about engaging in rebellion or insurrection. So Stanbury says, okay, this is what he's going to explicate this language in the statute, and he starts by saying that engaging in there you have to distinguish between active and passive engagement, participation in rebellion. Stanbury is here primarily addressing what it means to engage in rebellion, not insurrection. So you have to start, Stanbury says, by distinguishing between active and passive participation. Passive participation in rebellion doesn't count under the statute. So that's his first sort of distinction. Then he says there's a distinction to be drawn between voluntary and compulsory or involuntary participation in rebellion. So not only does the participation have to be active, but it has to be voluntary. If you are coerced to assist the rebellion, that doesn't bring you within the meaning of the statute. So one distinction, passive to voluntary or compelled. And then he has a third distinction between participation in official capacity and participation in a purely individual capacity. And he has a pretty extensive discussion of what official, voluntary, active participation in rebellion would be. That would include things like being the so-called Confederate States ambassador to France. Okay? That clearly is not being combated. Right? But then there's also a discussion of what it means to participate in rebellion in an individual capacity. And so the statute has to be understood in one way if the charge of engaging in insurrection is going to be charged against someone acting in an official capacity and then against someone who is charged with acting in an individual capacity. So to bring you under the statute, if you were acting in an individual capacity, would seem to require different tests from acting in an official capacity. And okay, let's talk about President Trump. One thing, if you just map on the interpretation Stanbury offers
I'm going to object to any opinion as to what President Trump did or did not do as undisclosed and outside of scope.
I don't have what he's going to say, but I'm going to sustain that objection.
Okay. Let me ask you about Stansbury's definitions as well. You said he was...
Can I just ask a question?
Sure.
You kept referring to the statute.
it's the Military Reconstruction Act.
Okay, and that's what Stansbury is
Yes.
calling them.
Yes. Sometimes called the Reconstruction. I think that's probably more common.
And you said Stansbury was talking or opining about rebellion primarily.
Yes.
Can you talk a little bit more about the differences, both in his analysis, rebellion versus insurrection, and how that applies to Section 3 of the 14th Amendment?
Well, most of Stanbury's discussion in the first opinion is about the engaging rebellion.
And why does that matter?
Well, it's not directly on point as to what engaging in insurrection means under the statute. It certainly sheds light. I'm not disputing that. I'm just saying it's not directly about engaging in insurrection under the statute. So it's certainly helpful. But to cut to the chase, I'm not sure that everything that Stanbury says in connection with engaging in rebellion carries over automatically to engaging in insurrection. Statute carries over automatically into engaging in insurrection, Section 3. These are all steps in the process. And then if someone charged with engaging in insurrection, it would have to be determined whether that engagement was in an official capacity or individual capacity. So as applied to someone, you would have to ask whether that engagement on his or her part was in an official capacity or individual capacity, which could be quite problematic to decide.
And why is that? What's I mean, how would Stansbury's opinion, to the extent it's possible to determine, apply to activity in a individual versus official capacity?
Well, this is all sort of uncharted territory, but not everything that Professor Maglioka says about Stansbury's opinion, because from it, not everything he says immediately translates into every single case. You have to decide whether the language he quotes about engaging in rebellion in official capacity also carries over to whether that is true of someone who engages in insurrection in individual capacity. So before applying his account, Stansbury's account, you have to decide, is this person acting in individual capacity or not? Is he acting individually? And does that matter? Does everything Stansbury says about engaging in rebellion in official capacity immediately carry over into such engagement in individual capacity? So construing Stansbury is quite difficult in itself, let alone reading whatever he says about the statute into Section 3.
So, did Stansbury provide standards or guidance as to exactly what constitutes or what type of liability attaches for actions in an individual capacity with respect to rebellion?
No, I don't think he talks about, at least not in the part headed engagement. I don't think he talks about the liability to which one was exposed. No, I guess he offers examples, I think, the standards about how to apply the statute term. But he doesn't discuss the liability to which, not in that part, doesn't discuss the liability to which someone who is found to have engaged in insurrection is exposed.
Does he discuss exactly how to determine whether a person has engaged in rebellion when they're acting in their individual capacity?
He does discuss that, and I don't recall exactly the language, but if we just focus on that part of Stanley's opinion, you'd have to make the threshold decision whether individual capacity, official capacity applies here, but he does focus on language about how you have engaged in rebellion in individual capacity. That's what that language is. I don't have directly in hand, but...
Okay. Now, he also, Professor Maglioka also compared the Stanbury opinions to the Worthy cases from the Worthy case from North Carolina, and he said that they were the definition for engaging in an insurrection was the same in the Stanbury opinions and the Worthy case from North Carolina. What's your opinion on that?
Well, Stanbury is talking about a statutory term, and the North Carolina opinion, the Worthy case, is talking about Section 3.
And tell me about the Worthy case. When you say talks about Section 3, that was a North Carolina state case, correct?
Yes, and it's decided under the state statute that incorporates Section 3 by reference and applies it to North Carolina and operationalized the enforcement of Section 3, at least as to state officials, state officers, not to federal officers or officers. It's relevant to understand. I don't think it's relevant to understanding what engaging in rebellion or insurrection means in the Constitution, Section 3.
And why is that? Why don't you think
it's really more relevant? Well, it's not identical with what Stanbury offers, but it's more relevant to the question of whether Section 3 is still executed.
Okay.
If it says the same thing as Stanbury, then it doesn't carry the ball further.
Okay. We'll get to the holding in just a minute, but is it your opinion that the definitions with respect to engaging in rebellion differ between the Stanbury opinion and the Worthy case?
Not that I can think of, no.
Okay. Okay. Go ahead. So you had talked a little bit about insurrection against the Constitution as used in Section 3, correct? Okay. What, if any, well, let me ask you this. To what extent do the historical sources allow us to create a specific definition of insurrection against the Constitution?
Well, I'm not aware of any discussion in Congress or ratification debates about that limiting principle against the meaning of the Constitution. I don't know.
And so you've looked at Professor Maglioka's sort of approach to limiting the Constitution. Are you able to create a definition of insurrection against the Constitution based on the historical documents?
Well, I would say this. I would look to guidance more to the remarks that Senator Jake Howard makes in introducing the 14th Amendment to the Senate, which are those remarks of Senator Howard are cited, I think, twice in Maglioka's report. And then have Senator Howard's exact language, though it appears both in Benjamin's report and mine. But Howard says something to the effect that this section of the Constitution is meant to cover actions to sanction actions that acts that are that pose I just don't have the exact word, but essentially grave to the threaten to help me if I could help.
Let's bookmark that. We're going to pull up the language for you directly in a second.
That would destroy was the term Howard used. It would destroy the Constitution. So, given Howard's role in the enactment, ratification of the 14th Amendment, it would seem to me I would start by looking at Howard's remarks on explicating the phrase rebellion or insurrection against the Constitution. And there would be acts that destroy the Constitution.
Your Honor, I'm going to object and move to strike the last answer on the grounds that his report never purported to offer any definition of insurrection or rebellion against the Constitution. This is a completely new testimony.
Your Honor, I don't think he said that Amendment 14, Section 3 has to be defined that way. He said the starting point is to look at Senator Howard's viewpoint as an analogy or a basis. I don't think he said that has to be the definition.
Did he disclose his opinion on the senator's remarks?
No, Your Honor.
If you could give me just a few minutes, Your Honor, let me look through his report and give you a point.
Can we come back to it?
Sure, Your Honor.
I think we'll probably break in the next 20 minutes and we can revisit that.
Okay. Okay. Professor Delahunty, we won't discuss Senator Howard's remarks at the moment, but why would you start from that as a foundation, looking at the remarks of the congressional debate?
Same objection.
Well, I don't think he's offering a different definition. That's why he would start looking there. It'd be helpful if we could see the remarks. I don't know if that's possible.
We're pulling them up right now, Your Honor.
Okay.
We may even have them. Okay. Can we scroll down to the part where he makes specific remarks? Your Honor, we're going to need to just spend a few minutes on this if we can come back to it a little bit later. I don't want to.
I mean, in general, it's been a little bit difficult to follow what he's talking about because he's talking about kind of things that we can't see, so to the extent that we can see the remarks that he's talking about, et cetera, definitely.
Okay. Your Honor, may I propose a morning break? That'll give us a little bit of time.
Sure. Why don't we just break till 10:30 and
Okay.
come back to it? We're back on, Mr. Kessler.
Thank you, Your Honor. Professor Delahunty, I've been asking you a little bit about talking about sort of certain case law to arrive at a definition of insurrection. But in your report, and I may have been going about it the wrong way in questioning you, in your report you talk about the difficulties of interpreting Section 3's offense element and defining what it means to have engaged in an insurrection. Do you remember that?
Yes.
Okay. And when you say interpreting Section 3's offense element, what are you referring to when you say the offense element in Section 3?
Well, Section 3 has essentially 4 elements. One of them is the language towards the end of Section 3, identifies the class of people who are subject to potential sanctions under Section 3. That, in my report, I call the jurisdictional element. Then there's what I call the offense element, and here I'm following Professors Tillman and Latin. The offense element defines what kind of conduct by the persons to which we subject to Section 3 have engaged in that would trigger liability. And the offense element is the language to refer to having engaged in rebellion or insurrection against the Constitution. Then the third element is the disqualification element, which says from what offices the persons who were subject to the section and had committed the offense in question would be thereafter excluded. And then the fourth section is the amnesty provision, which empowers Congress to extend amnesty purely or collectively to those who were jurisdictionally subject to Section 3 and had been found to commit the offense element and would have been excluded from the other offices but for the amnesty that Congress just given.
Okay, so let's focus on the offense element, which you describe as engaged in insurrection. And you've looked at a number of historical sources to try and derive what that meaning is, correct? Okay. And in your report, you talk about the difficulties of arriving at a conclusion, correct?
Yes.
Okay. Tell me about why you found it, or currently find it, very difficult to to reach a conclusion as to the offense element based on historical sources.
Well, it's really this, that I'm not aware of any direct definition of what it means to engage in insurrection against the Constitution. I don't believe there's any case law on that. Professor Magiogo offers his interpretation of what that phrase means. And that, as I've said and testified, is essentially to engage in interference with the, to commit insurrection against the execution of the Constitution. And that in turn is a phrase that is opaque, I would say. And really, all of it, I don't offer my own definition of what it means to engage in insurrection against the Constitution of the United States, because other than to gesture towards Senator Howard's remarks, because I don't know of any really good source to interpret that, which I think is not, my point is to underscore the difficulties a court would have, or really anyone would have, in interpreting that phrase, which is the crucial phrase, without such guidance, especially from Congress, which could define under Section 5 powers what it means to engage in insurrection against the Constitution of the United States. Congress hasn't enacted a statute that purports to provide us with that definition. That leads me to the conclusion that the courts, as a matter of constitutional policy, should defer to Congress and not decide a case on merits of whether or not someone had engaged in insurrection against the Constitution. There's just inadequate guidance, as far as I can tell, from relevant sources. So this is really the difficulty I experience in offering a definition, although Professor Magiogo seems more confident about it. The difficulty I experience, I think, should, if only for reasons of prudence, but really sort of constitutionally inflected reasons, lead the court to abstain from deciding what that phrase means and toss the ball over to Congress to act under Section 5.
Now, Professor Delahunty, I'm looking at our court, who I think has a inquisitorial look on her face. Your Honor, if you have a question, I'm certainly willing to defer for a moment.
I'm just trying, do you have examples of situations in which a court has basically said the Constitution is too hard for me to interpret, therefore I'm going to let Congress tell me what it means? In general, I think that that's exactly the job of the court, is to interpret the Constitution. And so I'd love to hear from you as to why you think in this instance that what I need to do is say it's too hard, Congress tell me what it means.
Not only a case law to say, this really case law approaches the question of whether Section 3 is self-executing. It goes more to that. It's sort of the prudential, or the constitutionally reflected, separation of powers reflected reason.
Okay, so it's really the self-execution question.
Yes.
Let me ask you this, Professor Delahunty. You looked at a number of sources in an attempt to reach a meaningful definition of engage in insurrection under Article 3, correct? And you looked at the prize cases. Do you remember that?
Not in that connection, but I do remember the prize cases, yes.
Do you think the prize cases were able to give you sort of a confidence on what the meaning of engage in insurrection
Well,
is?
first of all, the prize cases, which is probably the most important Supreme Court case during the Civil War, prize cases do help with distinguishing between organized rebellion, and insurrection. So, of course, that actually defining what insurrection means. It's certainly something to a degree less than rebellion. They're helpful in that way. But only so far. It doesn't explicate, because it wasn't in the Constitution at the time. The prize cases do not explicate what it means to engage in insurrection against the Constitution, because the 14th Amendment had been ratified not until July 1868. So they're not helpful in that way. They are helpful in a general way, in suggesting, saying that insurrection is different from a rebellion. That's something sort of more high grade than a riot, but something lower than a rebellion. And insurrection, I think the court there says something like, insurrections tend, in many circumstances, to lead to rebellion, but they don't have to lead to rebellion. So it helps that way. This was suggesting a gradient between rebellion, insurrection, and other kinds of disorderly conduct.
I'm going to ask you to stay a little bit closer to the microphone when you speak, Professor. I suffer from the same challenge here. And then you also looked at the charges in re charge to the grand jury. Correct. There was a particular case from 1894 from the Northern District of Illinois. Do you remember that?
Yeah, I think I do.
Okay. And after looking at that, were you able to have any confidence of what engage in insurrection against the Constitution meant?
Well, I think that No, not as to mean that precise phrase. No, it helps to understand what insurrection meant, at least later in the 19th century.
Okay. And then you also looked at, in case of Davis, which was a federal judicial opinion, talking about how insurrection or rebellion may be committed by giving counsel to enemies or others raising insurrection. Do you remember that? As a general matter. And my question really goes to all of these cases that you identified. Do they give you a sense of confidence in creating a definition of what engaged in insurrection against the Constitution is?
Not really. Not engaged in insurrection against the Constitution. Only they have to understand what engaged is. That's what insurrection is.
And even from the prize cases, the most you were able to glean is that insurrection is something more than a riot and something less than a rebellion.
Yeah, that's right.
Okay. In your view, looking at the sources and Section 3 of the 14th Amendment, and I think you've talked about this, but how does insurrection equate to insurrection against the Constitution?
No.
And why is that?
Well, self-evidently, they're different terms, and I agree with Professor Magliocca that some related principle should be imported into the term insurrection used in Section 3.
So I understood your testimony before to be that the problem that you have with Professor Magliocca's opinion is that he's saying insurrection against the Constitution is essentially an insurrection against the constitutional proceeding.
Against the execution of the Constitution.
The execution of the Constitution. And that those words...
What is interference with the execution of the Constitution? Yes.
Right, the words execution of Constitution are in there. And I guess, am I understanding what you're saying is that you don't know what insurrection against the Constitution means without adding those extra words, and that's why you think that Congress needs to decide?
Yes.
Okay, let me mercifully move on from the subject of insurrection. And I'd like to talk a little bit about the doctrine of, or the application of preemption, the enforcement of Section 3 by a state court. And do you remember opining about that in your expert report?
Yes, I certainly do remember some of the really crucial issues in this case and other cases. I report upon the meaning of officer of the United States as used in Section 3, and upon whether Section 3 is judicially enforceable by state or federal courts without some enforcement implementing legislation from Congress. And we report about what it means in the constitutional sense to have engaged in insurrection against the United States. And
okay.
There would be
so,
define that.
Okay. So we've covered the difficulties of defining insurrection. Let's talk about, well, let me ask you, we've got two more subjects I'd like to talk about. One is to whom Section 3 applies and whether it's enforceable or state or federal judicial courts. So let's talk about the enforcement provision, if we may. Okay? There were several instances of several actions that Professor Magliocca believed constituted enforcement. Obviously, you have a different viewpoint. Why do you believe that?
Can we start just with what provision, what clause in the article he was referring to as the enforcement?
Okay. What's the basis for your view that Section 3 is not enforceable by state or federal courts?
Well, it could be enforceable if there were appropriate legislation under Section 5. But just standing alone, I'm not really talking about clause because...
Let's stay a little closer to the microphone. I know you're being a professor and moving about to keep the audience engaged, but I'm going to ask you to be glued to that microphone, please.
The question is, how is Section 3 to be enforced? Can it be enforced by a court, state, federal, independent of any action by Congress, or not? There's some enforcement mechanism that Congress provides necessary for the enforcement of Section 3. Put it simply, can I just show up at a courthouse one day and ask for Section 3 to be enforced, or does there have to be some implementing mechanism to enforce Section 3 that Congress is providing?
And what's the basis for your opinion that that as currently, based on the historical documents, that the Section 3 is, Section 3 is not enforceable absent action from Congress?
Well, my reasoning is this. First of all, as a general matter, the Constitution should not be understood to provide enforcement actions for its provisions directly. We're taking the naked Section 3, or two cases from the Supreme Court, the Supremacy Clause, which declares that federal law is Constitution, statutes, acts of Congress, and treaties are supreme law. So in these two Supreme Court cases, the latter of which was from 2015, the court ruled that the Supremacy Clause was not directly enforceable.
And Your Honor, I'm going to object. To the extent he wants to talk about historical sources, that's one thing, but to the extent that he wants to talk about his interpretation of contemporary judicial precedent, I don't think that's proper here.
I think we'll be able to tie it up, but I'm certainly happy to start with a different approach, Your Honor.
Okay, because I tend to agree with Mr. Murray. So I'm sustaining that objection.
Okay. Looking at the historical record, I believe that you referred at one point in your report to and as has Professor Magliocca, the Griffin's case.
Yeah.
Okay. Could you explain how that's relevant to the self or non-self-executing nature of the 14th Amendment, Section 3?
Well, the Griffin case is decided not so long after the 14th Amendment, including Section 3, is ratified. And I think it helps us to understand what, in the mind of the framers and ratifiers of voters generally, Section 3 was understood to mean. And it's an opinion by the Chief Justice of the United States, Samuel Chase, that addresses the question of whether Section 3 can be directly enforceable without amending legislation, or whether amending legislation is required. So those are the bases of Chase's opinion. And Chase was not only the Chief, it's not an opinion of the Supreme Court, it's an opinion by Chief Justice Chase, writing cert. But it's soon after the Section 3 was ratified and put into the Constitution, and it's by someone who was not only Chief Justice, but a very fine lawyer and a politician and a potential candidate for the presidency at the time. And it's soon after the ratification of Section 3. So I think it's weighty authority as to what Section 3 does and does not do in the absence of action by Congress under Section 5, the enforcement provision of the 14th Amendment. And Chase holds that, it's one of his three holdings, that Section 3 is not directly judicially enforceable. And that strikes me as very powerful evidence. I'm not saying it's a binding precedent. For one thing, it's by a justice of the Supreme Court. Well, it's not. It's not a decision of the Supreme Court. But it strikes me as very powerful evidence as to the original public understanding of what Section 3 did. And there was consideration given in Congress, even before Chase's opinion in Griffin's case. There was consideration about the need to enforce Section 3 by acting under Section 5. And that ripened into enactment in 1870, after Chase's opinion, the enactment of the Enforcement Act of 1870. So Congress took the signal from Chase that Section 3 needed enforcement. There were other reasons even before Chase to think that it needed enforcement. And Daddy Stevens, who was the party speaker of the House, told the House it needed to step up to the plate and enforce the right legislative mechanisms to enforce Section 3. But it is relevant to a question before the court here of whether it can, without congressional action, decide whether to reach the merits or whether it needs some congressional action before it does it. This applies to both state and federal courts. Now, the word case, I think you mentioned that, and it's certainly pretty prominent in Professor Magliocca's testimony. The word case is a North Carolina case which is decided before Griffin's case, doesn't take account of it, simply doesn't undercut Chase's opinion because it's the word case is decided in January of 1869. Chase's opinion comes down in late July of 1869. If I were a judge in North Carolina and knew of and studied Chase's opinion in Griffin's case, I would have discussed it in my opinion were they come 6 months after Griffin's case. I would certainly have taken account, positively or negatively, but I would have taken account of what the Chief Justice of the United States had said in Griffin.
What was the Worthy case about? Was that actually a direct interpretation of the U.S. Constitution?
Well, as I read it, the North Carolina court is acting under a North Carolina statute that incorporates and makes state law qualifications based on Section 3. It's not direct enforcement of Section 3 per se. It's enforcement of a state statute that takes Section 3, incorporates it, and applies it to state officials and state officers, which, of course, a state can do. A state can rule on the qualifications or disabilities or whatever of its own state government officials. And it can do. And I think that's what North Carolina was attempting to do. So, as to whether globally, Section 3 per se, self-enforcing, I don't think Worthy has much overpresented as any capabilities.
Okay.
Of course, I think explicit, I think we see it's acting under North Carolina statute.
Now, shortly after Chief Justice Chase issued a decision in the Griffiths case, with respect to the self-executing nature. He also ruled in another case, second Griffiths case, that was, I believe Professor Maglioka and others have stated contradicts his earlier viewpoint on, or his earlier ruling on self-execution. Can you address that, please?
Yeah, the argument that Professor Maglioka and others make is that Chase took inconsistent positions on the enforceability of Section 3 in the Jefferson Davis case from what he said in Griffith's case. First of all, I would say it's not absolutely clear why Chase said or wrote in the Jefferson Davis case. That's a dispute among scholars, but I'm going to assume that he was of the view and that in the Jefferson Davis case, Section 3 was not self-executing. So let's posit that there was a contradiction between Chase and Jefferson Davis and Chase and Griffith. Let's posit that. I don't think that matters because judges, professors, can change their minds, and maybe did. But the real thing to look at is the quality of his judicial reasoning in Griffith's case. We don't really have an account of the judicial reasoning he may or may not have had in Jefferson Davis' case. So we do have this leading authority in Griffith's case by Chief Justice. If he's trapped in some kind of contradiction, doesn't that really matter? Look at the quality of the reasoning in Griffith's case. But in any event, even if we do catch Chase in some kind of opposition, contradiction, I think, even if we think we have, I would say that the two cases are reconcilable because Jefferson Davis's legal counsel appeared to have been threatened to use Section 3 as a defense in Jefferson Davis's, it never happened, but in his forthcoming trial on violating the federal treason statute. So that would have been a defensive use of Section 3, and maybe Section 3 can be used defensively against a charge of criminal treason. I'm just not sure about that. We don't have any ruling because what happened with Jefferson Davis was that President Johnson pardoned him, and that short-circuited any trial just didn't never happened. Pardoned him from the charge of having committed the federal crime of treason. So Davis's lawyers said that they were planning to use Section 3 as a shield defense to they sort of thought that Section 3 had displaced or overcome the treason statute in his respect. Whereas in Griffin, Chase was really saying that Section 3 could not independently, directly be used as a sword to base a claim to affirmative relief. And the plaintiff, who was a prisoner, was seeking federal habeas relief, so affirmative relief, based on Section 3. That would be using Section 3 as a sword. And Chase reasoned it's not self-executing in that sense. And that opinion, Chase's opinion in Griffith's case, was cited affirmatively, and even the sword shield distinction in it was approved of in a 1979 Fourth Circuit. So Chase's view about the way in which Section 3 was non-self-executing, Chase's view was considered good law until, at least until 1979. I think it's good law, but it's a lot. But certainly in the minds of federal courts, it was good law as late as 1979. That case is called Cole versus City of Covington.
Okay. Did you come across any historical documents or analysis that leads you to conclude that Congress embraced Chase's interpretation of Section 3?
So, the question of whether various iterations of Section 3 would be self-enforcing or not came before Congress, actually pretty early in the process of ratifying Section 3. Thaddeus Stevens, who was kind of the leader in the House of the radical Republicans, said the version of Section 3 he preferred would need congressional implementation, and he reiterated that when leaving Congress in 1858. So there's that. But after Chase, now to my knowledge, there's no mention explicitly of Griffin in Congress after it came down. But I think it's reasonably safe to assume that Congress, after 1869, was aware of the opinion of the Chief Justice of the United States. It's much more likely that they knew of in Griffin's case than in Worthy's case. And after that, Congress decided, yes, we will enact implementing legislation that is kind of reinforces Tracy's view because it provided in the Enforcement Act of 1870 a mechanism by which a federal district attorney could, in certain cases, bring Section 3 cases against in court against certain federal officials. They accepted senators and members of the House, but against another class of officials, the federal district attorney was authorized by this federal statute to bring enforcement actions in federal courts alone. So that was how, as I see it, Congress responded to Chase, even though, to my knowledge, it didn't explicitly, nobody in the case explicitly referred to.
So your view is that congressional enactment, the Congress enacted implementing legislation for Section 3.
Pretty soon after, yeah.
And so, sort of based on your approach to this historical analysis, your view is that they knew about the Griffins case or were likely to have known about it?
Yes.
And why is that?
Well, it's depending upon Chief Justice.
Okay.
So under this theory, essentially, wouldn't the question of whether this provision of the 14th Amendment is even exists, right? I mean, on Congress, so I mean, it's essentially giving Congress the power to decide what amendments to apply or not apply.
Well, if they're going to be
Could you please move?
Sorry, that's what
I'm sorry.
If they're going to be applied to source to see really, I think this action, it doesn't originate with this congressional, it just doesn't originate with Griffin's case. But it maybe it's prompt by Griffin's case, and it, I think, corroborates, reinforces Chase's conclusion that Section 3 is not self-exclusionary in that way.
My question was just a little bit different, which is if the only way to enforce a constitutional provision such as this is through legislation, then essentially isn't it leaving to Congress to decide whether or not the prohibition exists at all?
Yes, I mean, unless you try to implement it in the way like Carolina did through a state statute that incorporates Section 3 by reference. But because I really want to be responsive to your question. Yes, I mean, in fact, I think Stevens at the time basically was saying, even earlier, Stevens was saying, hey, Section 3 is a dead letter. It's a dead letter unless we provide some enforcement mechanism. And, you know, generally speaking, Congress at the time wanted to take charge of the Reconstruction program. And so I think people like Stevens were saying, we want to decide how and when and whether to enforce Section 3 or view it to be a dead letter. Obviously, Stevens thought that was a very poor idea, but that's what he was saying. He wanted his colleagues, we can't let this stay a dead letter. And so in the Enforcement Act of 1870, they basically said, we're going to leave it a dead letter, at least for now, as applied to people like us, members of Congress. But we're going to make it a live letter when applied to another group of people who aren't in Congress. There was that threat that it would be a dead letter and not judicially enforceable.
In your opinion is today, it's a dead letter. It's essentially.
No. My opinion is that it is not judicially enforceable absent either incorporation as applied to state officials, which is what North Carolina did, or it's not enforceable offensively without an act of Congress, without implementing legislation.
So if Colorado had a statute that adopted Section 3 of the 14th Amendment, is your opinion that then it would be enforceable?
It would be enforceable in Colorado as applied to state officials, candidates, state officers. Outside of that, I think it's not by state law outside Colorado.
So at a federal level, your opinion is that Section 3 of the 14th Amendment is a dead letter, essentially, a non-existent constitutional provision because there's no way to enforce it?
Well, no, I don't think it's a total dead letter. We don't know whether it could have been used defensively, as Jefferson did this or not. But it, like much of the 14th Amendment, it requires congressional action to provide a course of action in the court. There's just,
Go ahead. I'm just trying to make sure
Professor Delahunty, I'm going to ask you to wait until the sirens go by. That's one of the unique characteristics of this courtroom.
So the baseline for understanding the Constitution globally is set by the Supreme Court in these supremacy clause cases that I mentioned earlier. That's the default position. The Constitution generally, globally, whether it's Section 3 or the supremacy clause, the Constitution is not self-enforcing in the relevant sense. And the court in the latter of these two cases, the Armstrong case, explains why the Constitution is not automatically self-enforcing, why it needs guidance. And that is because Congress has to set the policy of the United States and can decide whether and how far to enforce constitutional provisions and whether or not to. That's the general assumption. The Constitution has a general matter is not self-enforcing. So that's the Armstrong case.
Your Honor, may I continue, or do you have
No, of course.
further
Sorry to
follow-up?
interrupt.
So let me ask you about historical examples of Congress refusing to seat members for whether viewed as treasonous or rebellious or types of behavior that would fall under the ambit of Section 3. Are those examples of congressional enforcement of Section 3?
Well, I don't think they are, because if I recollect that part of Professor Nadeau's report, these two exclusions occurred before Section 3 was ratified, so they're not. Congress has the power to exclude members elect, and that power is limited under the powers of the court, but maybe in this relevant period close to ratification of Section 3, Congress took a review of its powers to exclude members elect, and it acted under the provisions in Article 1 of the 14th Amendment, enabling it to exclude members elect.
Okay.
For good cause. Now, that's been tightened, the exclusionary powers of Congress. We don't know what the Supreme Court in Powell versus McCormick specifically withheld finding on the question of whether Section 3 is a disqualification and a basis for congressional exclusion. We compel that judgment.
Okay. Let me excuse me one moment, Your Honor. I just need to look at something. Let me move on to I'm just double checking my notes here. Were you able to identify any instances in the historical record of your view where Section 3 was enforced by state officials in state courts? Not a state incorporation into state statute of Section 3 standards, but Section 3 itself directly enforced by state courts?
No.
Okay. Okay, let's move on to the third item that you had discussed in your report, in your opinion, with respect to an officer of the United States. Although before we move there, is there anything else that serves as the basis for your opinion that Section 3 is not self-executing?
Well, I do the basic reasons, including the Fourth Circuit's reference to reliance on Jackson application. Let's move the framework of Jace to the case before it, which was wrongful discharge actions based on assumed cause of action directly under the 14th Amendment.
Okay. Let's talk about the phrase "officer of the United States." Let me ask a question, and then we'll head there. So, what's your response or your opinion on Professor Magliocca's conclusions that the phrase "officer of the United States," as used in Section 3, includes the President and Vice President of the United States?
Well, I disagree with that. And more, I looked into that question more. I was persuaded it's really wrong. I think that term is, in essence, a term of art and had a specialized meaning. And this leads me back to the question of whether I had consulted legal dictionaries, like Noah Webster on the meaning of insurrection. There is a legal concordance. Now, is that a dictionary? It already looks like a dictionary. It's from 1883, I think, by John Lawler. And it offers legal definitions of various terms, including the term officer, and it cites supporting case law for its definition. That definition of officer has a separate, compartmentalized understanding, definition of officer of the United States. Right? Now, this is 1883. It's later than the application of Section 3, but it's not too long after the conclusion of the Reconstruction period, which is commonly dated to 1876, the election of President Hayes. And so I think it's fair to say that officer of the United States was understood by the legal community, and people who had read this concordance looked up the definitions of it. I think it's fair to say that officer of the United States was understood to be a special term needing separate definition from officer generally.
And so what other sources did you look to define what officer of the United States means?
Well, there is the language, the text of the Constitution itself, and then there are a long variety of Supreme Court opinions, going up to a fairly recent one by Chief Justice John Roberts, defining what officer of the United States means for purposes of the Appointments Clause in Section 2. Some of these Appointments Clause cases are roughly around the time of the ratification of Section 3, and include lower court federal cases about the definition of the term officer of the United States. And of course, it or very close copies to it appear in the text of the Constitution itself. And so far as possible, wants to construe these constitutional uses of the term officer of the United States to be consistent, to be the same. So the text of the Constitution uses the term in several contexts, and the meaning should, by ordinary rules of construction, be consistent from one such provision to the next. So I think both the text of the Constitution, especially if you assume this rule of consistent meaning in different uses, the text of the Constitution and the Supreme Court case law support the view, strongly support the view, that the term officer of the United States means the same thing in Section 3 as it means in the Appointments Clause. That the Appointments Clause is kind of the anchorage, if I may speak that way, of interpreting the meaning this way as officer of the United States. Elsewhere in the Constitution, outside the Appointments Clause, including Section 3.
And why is it considered the anchorage?
Well, because of the principle, because of the case law, Supreme Court case law, some of the very recent, but also because if the term is to be used in a consistent way through the text of the Constitution, then it's got to mean elsewhere what it means under the Appointments Clause.
Now, did you also look at the impeachment clause and the drafting documents involving the drafting of the impeachment clause as part of your opinion?
I don't know if I looked directly. I didn't look closely at other than a cited court opinions, I don't think I looked at the original pre-1788 documents. No. Did I look at the case law? Yes. And the case law, I did consult secondary sources about the process of drafting the impeachment clauses, and the secondary sources show, I think, that as used in those clauses, the officer of the United States had a meaning that was designed to exclude the president. There's separate rules about presidential impeachments from impeachments of lower executive level officials and federal officials. There's a separate treatment of those officials in the impeachment clause. So thanks.
Okay. Let me. You also talked a bit about the, with respect to the jurisdictional language of Section 3 involving the oath clause. I'm sorry, we talked about that in Article 6. Are there any other documents or bases of your opinion that an officer of the United States excludes the president and vice president?
Well, I think the language that the Constitution uses for prescribing an Article 6 oath is slightly different from the language the Constitution uses in prescribing a quite separate presidential oath in Article 2 of the Constitution. There are two oath clauses, an Article 6 one and an Article 2 one. Okay? And the Section 3 of the 14th Amendment echoes the oath language of Article 6, where those who are subject to it have to take an oath to support the Constitution. If you go back to Section 3 from the oath clause in Section 6, it appears quite clear to me that they were talking about the class of people who had to take the Article 6 oath. Not the people who were talking, that they didn't mean the Article 2 oath clause. I think that's, now, Professor Maglioka says that, and he cites a grand jury judge from the 19th century, that allows for some plain and joints as to what it means to take an oath to support the Constitution. That can be, his historical source says some plain and joints, some elasticity. But so what? That doesn't assimilate the Article 6 language, where the president has to swear to preserve, protect, and whatever else it says, the Constitution. You can't just assimilate the language of the Article 2 oath clause into the language of the Article 6 oath clause. That's beyond plain and joints. It's a separate language about how what the president's constitutional responsibilities are.
Now, how do you respond, and I believe Professor Maglioka said, look, an oath to protect and defend is essentially an oath to support, so they're effectively the same thing.
That's stretching the language much too far. I mean, people who draft constitutional language have to be very, very careful about the terms they use, especially if those terms are related elsewhere in the text of the Constitution. So I think it's going to be too far. I once ago was tasked with trying to draft an amendment to the Constitution that would give up in the end. So
And what's the basis for your opinion that people who draft the draft constitutional provisions are very, very careful about the language they use?
What's the basis of my opinion?
Yes, and if you could explain to me the basis in the microphone, that would be great.
Yes. Well, look, there's a principle that Professor Lamar discusses at length in an article called, I think, Introtextuality, where he shows that you should, if you are asked to, interpret the same term in different occurrences in the Constitution in the same consistent way.
And Your Honor, I'm just going to object to you talking about gains of construction among modern scholars as opposed to historical sources.
Sustained.
Okay. So let me ask you, did, as a matter of historical analysis and knowledge, did the people who drafted Amendment 14, did they take care about the language they used and understand when they used language that mimicked other language or was different than other language? Let me try rephrasing.
The drafting of section,
That was a terrible question I was about to say.
Sustain your
No, I'm not objecting to my question, Your Honor. I'm simply withdrawing it. So, in using the term officer of the United States or using an oath to support versus a different type of oath, the care and usage of language, did the framers of the 14th Amendment pay conscious attention to the very specific words they were using and how that did or did not reflect other usage in other parts of the Constitution?
well, the initiative to draft an amendment to the Constitution came very early after the Civil War because it was considered why there was need to bring the Constitution up to date, and in particular, need to get rid of Dred Scott and so the Congress, very, very early in its term, set up a 15-member joint committee, including members of the House and Senate, to do exactly that. They included some very fine lawyers and very thoughtful people, and the committee considered several draft versions of what later matures into the 14th Amendment, including Section 3. And those proposals, which ripened over months, by leading members of both houses, then are presented to the House and Senate for consideration, again by very able lawyers. And do I have make sure that everything clicks into place? No. Do I make the assumption based on the care and length of the deliberations that the Select Committee and houses gave and the attention that was given to it to determine exactly who was covered, whose jurisdiction is subject? Do I make the assumption that that was given careful consideration to bring it into line with the rest of the Constitution, or else depart from the standard meaning? Yes, that is an assumption I would make.
I have no further questions. Your Honor, if you have any further questions, we certainly appreciate the discourse that you may have.
I was just wondering, Professor Delahunty, he showed us some discussion about the enactment of Section 3 of the 14th Amendment, in which one of the senators stated, don't want to make sure that this applies to the president. And then somebody responded and said, well, it applies in the kind of catch-all phrase. And then the gentleman says, oh yeah, I see you're right. So how does that discourse, which impact your opinion in this?
That's Senate colloquy between Senator Beverly Johnson of Maryland and Senator, I can never remember what it was, Maryland. That colloquy concerns the disqualification clause of Section 3, not the jurisdiction clause. So it is relevant to interpreting from what offices a covered person who has committed the relevant offense will be excluded. That's the start of the language in Section 3. But it doesn't go to the coverage of the jurisdictional coverage of Section 3. You can't just map on the leading language of Section 3 about from what offices shall this person be excluded onto who is covered by Section 3. It goes more to whether the presidency as an office is included in Section 3. Then it goes to the question of the president is or is not an officer of the United States. So I don't think it's relevant to the interpretation of the judicial jurisdiction aspect of Section 3.
Thank you, I appreciate that.
Your Honor, we have no further questions, and with that, we will release the witness to opposing counsel for cross. All I know it's about 11:30.
So let's just talk for a second about timing. I know that you're planning on having Mr. Healy at 1. Is that like a hard time, or does Mr. Healy have some flexibility in his schedule?
Mr. Grimsley can talk about this schedule.
Your Honor, that's a pretty hard time for him. He teaches class in the evening, and he's on the East Coast, so that's 3 o'clock for him, his time. So I think it would be fine with us to take him out of order, and just as much as I don't want to interrupt the cross-examination, I think it would make sense to do so.
And I guess a question for you, Professor Delahunty, is are you available to finish your cross-examination after we take this other witness, or are you available today?
Today, yes.
Okay, it would be today. It just, we may go till noon and then break for lunch to Mr. Keithy and come back to you sometime later in the afternoon. Is that okay with you?
Yes.
Okay. So let's do about a half hour of cross-examination, and if you're finished, we'll finish it after Mr. Keithy.
Yes, Your Honor, thank you. Let me just make sure we've got me up on the screens here. Looks like we're on this one, but not this one.
You may proceed.
Good morning, Mr. Delahunty. You're not claiming to be an expert in the history of Section 3 of the 14th Amendment, are you? And certainly Section 3 of the 14th Amendment is not the main focus of your scholarly work, correct?
It has been for very few academic institutions.
I want to look briefly at some of the things that you have published academic literature on. This is Petitioner's Exhibit 315. Is this your latest CV?
Yes, I think it is. I did ask counsel to submit a slightly updated CV.
Yes, and this is the one we received, I believe, on Wednesday of this week. On page 3 of your CV, we have some articles and book chapters here, and one of those is a book chapter, Deconstructing the Deep State, in the book Up from Conservatism. Do you see that? And you've also written on, for example, the Major Questions Doctrine and the Administrative State.
Yes.
You mentioned some publications on Shakespeare. Is this one of them here?
Yes.
And at the bottom, there's another one about Shakespeare's King Henry and Just War. Is that right?
Yes.
You have a lot of publications on foreign affairs and international law, such as Toward a Concert of Asia and the Crimean Crisis and the use of weaponized drones. Is that right?
Well, the first one was accepted for publication, and then I think this publication by the University, by a journal from the University of Pennsylvania wasn't actually published, it wasn't rejected. I think they just started down, but yes, in that sense.
But those are-
Accepted for publication, yes.
And those are things you wrote.
Well, I never published, I don't know exactly, but it's a big zero.
Do you mind just speaking a little bit closer to the microphone? Thank you.
I mean, I think I gave full disclosure, accepted for publication, but was not published.
And nothing.
I make it zero.
Oh.
I understand.
Oh, no, I'm sorry. I may have misspoke. But let me ask you another question. Nothing on this page of your CV relates at all to Section 3 of the 14th Amendment. Is that right? And I'm not going to go through every item in your CV, but just on the next page, we do have some additional articles on things like international law, the laws of war, the Bush Doctrine, Latin America, things like that, correct?
Yes.
And again, there's nothing on this page, no publications that relate to Section 3 of the 14th Amendment. On the next page of your CV, once again, there's articles on international relations, on the Kosovo crisis, on why American and European attitudes towards international law differ, on against foreign law, and things like that, correct?
Yes.
And again, on this,
Well, if I may say, the piece about against foreign law is about constitutional interpretation, whether foreign law should be imported into the interpretation of constitutional clauses.
understood, and in your article against foreign law, you weren't discussing Section 3 of the 14th Amendment.
So the whole nature of cross-examination is that they're usually yes or no answers, and you kind of know where he's going, so you're tempted to answer before he finishes, but that'll wait just for the court record, okay?
Okay.
And if we go to the next page of your CV, we have a few more articles on things like the Geneva Convention and the President's authority to conduct constitutional authority to conduct military operations and foreign affairs matters. Is that correct?
Yes.
You've also written on philosophy. For example, you have an article about Descartes, correct?
Yes.
And you've written a book on the philosopher Baruch Spinoza, true?
Yes.
You've never written a book with a central focus on the history of the 14th Amendment, have you?
No.
These days, you write a lot of political commentary, is that right?
Yes.
For example, you write articles and op-eds in Fox News and the National Review and the Federalist.
Yes.
For example, you wrote an article with John Yoo entitled Pushing Back on Cancel Culture. Do you see that?
Yes.
And on the next page, you have a number of articles about China and COVID, such as how to make China pay for COVID-19, correct?
Yes.
And if we go a few pages down the line, there's articles about things like the South Korean election, the Persian Gambit, and Brexit, correct?
Yes.
Do you remember writing an article in the Federalist this summer about why, in your view, Democrats can't ditch Biden?
Yes.
In that article, you claimed that Biden was suffering from what you called embarrassingly obvious cognitive decline. Is that right?
Yes.
In that article, you said that President Biden is surrounded by the stench of corruption, and you cited evidence from, quote, the Hunter Biden laptop. Do you remember that?
Yes.
In that article, you also discussed, quote, the pouch of cocaine found in Biden's White House. Do you remember that?
Yes.
And in that article, you referred to the Democrats and their deep state enforcers in the FBI and CIA. Do you recall that as well? You've never written a peer-reviewed article with a primary focus on the history of the 14th Amendment. Is that right?
That's right.
You've never published a peer-reviewed article about Section 3 of the 14th Amendment, correct?
No, no.
And you have published one article talking about Section 3. Is that right?
Yes, not it.
That was an op-ed in the Federalist in August of this year.
That's right.
You'll agree with me that your op-ed in the Federalist was not a work of historical scholarship, right?
That's right.
It doesn't cite very many historical primary sources.
No.
You've never given expert testimony before, correct?
Correct.
I want to ask you a few questions about historical methodology. When you're doing historical work, I think you said on direct that you look at primary sources, correct? And it's always better to go back and look at the original primary sources than it is to take some secondary sources' word for what those primary sources say. Were any of the sources that you discussed on direct examination sources that were uncovered through your own original archival research?
No.
In your report, you said that you gave a draft of your report to Professors Blackman and Tillman. Do you recall that?
That's right.
And you said that you gave Professors Blackman and Tillman a draft of your report because they have, quote, written extensively on the subjects discussed in my report, right? Unlike you, Blackman and Tillman have written extensively on the subject of whether the president is an officer of the United States under Section 3 of the 14th Amendment.
That's correct.
But you know that not all scholars agree with that view, right?
I do.
You know that Professors William Bode and Michael Paulson disagree with that view?
I said it.
Did you ever ask Professors Bode or Paulson to comment on your draft report?
No.
You know that Mark Graber disagrees with the Blackman and Tillman view that the president is not an officer of the United States, right?
Well, I haven't read the regular piece, but I assume that he is in reason, or disagree with Tillman and Blackman.
You haven't read Mark Graber's piece discussing the history of Section 3 of the 14th Amendment.
No.
And so you never asked Mark Graber to comment on your draft report either. Did you ever give a draft of your report to John Vlahopoulos?
No.
Do you know who that is?
Yes, I've seen references to his recent work.
He also wrote an entire article responding to the Blackman and Tillman position that the president is not an officer under Section 3, right?
I didn't know that, but yes.
You didn't know about that article, and you didn't read the article where John Vlahopoulos responds directly to the Blackman and Tillman position in the context of Section 3? You didn't solicit comments from any scholars who disagree with your opinion on whether the president is an officer of the United States. I want to ask you about some of the sources you do rely on. I want to pull up your report, Petitioner's Exhibit 227. And does this appear to be the expert report that you served in this case?
Yes.
Do you recall that in your expert report you have, starting on page 5, a background to Section 3 of the 14th Amendment?
Yes.
And if we scroll through, just that section is about 7 pages long, and it goes until page 12 of your report.
Yes.
In that entire section, you don't cite a single primary source, do you, sir?
I don't think so, no.
You do cite to Professor Kurt Lash's recent article on Section 3, though, right?
Yes.
And certainly, you don't cite any original historical research that you've done.
No, not in the background. No.
And in this article by Kurt Lash, that's your only citation in your background section. That's a draft paper that hasn't been published yet, right? That was actually posted on SSRN just a few weeks ago.
That's right.
I want to look briefly at Professor Lash's draft paper, Petitioner's Exhibit 289. Does this appear to be the article from Professor Lash that you relied on?
It does.
If we go to page 3 of Professor Lash's article, there's a footnote here, footnote 5, and it says, a robust scholarly debate has emerged regarding the proper reading of Section 3 terms, such as office and officer, and those who have previously taken an oath as an officer of the United States. Do you see that?
Yes.
And then he cites a number of scholars, right?
Yes.
And some of the scholars he cites are Josh Blackman and Seth Barrett Tillman, who you said you sent your draft report to, right?
Yes.
He also cites William Bode and Michael Paulson, right?
Yes.
And he also cites Mark Graber, whose paper you said you never read, correct?
You mean that particular citation? I'm not sure. He's involved in that.
He also cites, as a contributor to this robust scholarly debate, Gerard Magliocca, who you understand is petitioner's expert in this case, who testified earlier this week, correct? Professor Lash does not list you as having made any contributions to the robust scholarly debate about the proper meaning of office and officer under Section 3. Is that right?
That's right.
If we go to page 48, there's another footnote, and it's a long footnote. I'm not going to ask about the substance of what the sources are talking about, but I just want to ask you, do you see in footnote 218, Professor Lash cites an opinion reported in the Times-Picayune and a jury charge reported in the Tennessean?
Yes.
And at the end of that footnote, Professor Lash says, my thanks to Gerard Magliocca for the pointer to these opinions, correct?
Yes.
Nowhere in Professor Lash's article is there an acknowledgement given to you for any contribution that you've made to the historical record on Section 3, correct?
That's right.
And in fact, Professor Lash's article doesn't cite you anywhere in his draft article. Is that right? Your Honor, at this point, we would renew our motion to exclude the testimony under Section 702.
I'm going to deny the motion. As I said, Professor Delahunty has expertise in reviewing historical documents and applying them to constitutional provisions, and his lack of a scholarly contribution to Section 3 in particular, I don't think excludes him from testifying on opinions that he's testified to today.
Thank you, Your Honor. At this point, I'm going to move on to the substance of his opinions, but I know we only have a few minutes left, so I wanted to see if you wanted me to start with that, or if we wanted to just break for lunch now.
Why don't you start, just since we're running a little bit behind today, to go for about 10, 15 minutes and maybe take a little bit shorter.
Sure. Mr. Delahunty, I believe you said on direct that the 14th Amendment was, that you begin your constitutional law classes with the 14th Amendment. Is that right?
Yes.
And you called
I'm sorry, I said, we got to do Scott, typically.
Dred Scott and then a discussion of the 14th Amendment?
Yes.
And you referred to the 14th Amendment as a second founding of our Constitution. Is that right?
Yes.
The 14th Amendment is not some kind of second-class constitutional amendment. You'd agree with that, right?
Well, I don't think you can make it. What is, may I ask a clarification question?
You can ask him to repeat the question, but I'm just going to admonish you again to let him finish his questions before you start to answer.
Okay. I don't understand the distinction you're trying to draw, counsel, between first class and second class amendments.
Well, I'm not sure I do either. I'm just trying to make the point that there's nothing that says that the 14th Amendment is somehow lesser than any other constitutional amendment, right?
That's not based on any complaint.
So I want to start by talking about your opinion that Section 3 is ambiguous and that therefore it needs congressional enforcement legislation. You'd agree with me that courts interpret ambiguous text all the time, right?
Indeed.
Courts interpret unreasonable searches and seizures in the Fourth Amendment, for example.
That's right.
And even in the 14th Amendment, they interpret terms like due process and equal protection, correct?
Yes.
Are you aware of judicial decisions saying that we can't tell what an unreasonable search and seizure is or due process of law is unless Congress tells us?
No, I'm not aware of any such decisions.
When you teach constitutional law, do you teach Marbury v. Madison?
Yes.
And that's a case where the Supreme Court, Chief Justice John Marshall said it's emphatically the province of the judicial branch to say what the law is, right?
It is. Yes.
You know that courts interpreted and applied Section 3 pursuant to state law even before Congress enacted implementing legislation, correct?
True.
Your opinion, one of your opinions is that it's difficult to understand how the phrase insurrection was defined during Reconstruction, correct?
Well, I don't know that it was defined at all, but it is difficult to interpret the term.
But you agree with petitioners that Section 3 remains in force even outside the context of the Civil War.
I do agree with that. And so stated in the report.
And you agree that Section 3 has continuing relevance to any future insurrection or rebellion.
I agree with that. Yes.
You also agree that insurrection need not rise to the level of an organized rebellion.
That is what the Supreme Court says in the prize cases. I agree.
And the prize cases were cases that came up during the Civil War where the Supreme Court said just that, right?
Say.
Where the Supreme Court said that an insurrection need not rise to the level of a rebellion.
Yes.
An insurrection also need not rise to the level of a civil war. Is that right?
Yes.
You're not saying that a criminal conviction or a guilty plea on a charge of insurrection is a necessary condition for a Section 3 disqualification.
No.
On direct examination, when you were talking about the president's oath versus an oath to support the Constitution, you said that the drafters of the Constitution were very careful with their words. Is that right?
Yes.
Is it your testimony that they were so careful with their words that they used a term, insurrection, that just had no clear meaning?
I don't understand.
Well, you testified that the framers were careful with their words, but you've also testified that insurrection is a sufficiently unclear term that we need Congress to tell us what it means. Is that right?
Did I testify to that? I remember, I think I probably did, yes. Certainly that question would be helpful, instructive to, of course, legal system who's very important age. There's also the question of whether the court's going to enforce it or not, Section 5 action, but that's separate, I think, from what I'm asking.
Can I just ask you to speak a little closer to the mic? Thanks.
The question is a bit complicated because it implicates Section 5 of the 14th Amendment as well as Section 3.
And other provisions of the 14th Amendment, like Section 1, also implicate Section 5, right?
Yes.
Now, if I have trouble knowing what a word means, sometimes I go to a dictionary. So let's look at some dictionaries. And this is Petitioner's Exhibit 144, the appendix of materials that we looked at with Professor Magliocca. Page 785, I believe he testified about Webster's on direct, but we didn't look at it. Webster's, in the antebellum period, defined insurrection as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state, correct?
Yes.
And Webster's was not the only dictionary in the antebellum period that defined insurrection in just this way, was it?
I think that Webster's definition is the essence of it, maybe not word for word, particularly execution of the law in a state or state. Widely accepted, maybe even followed.
You cite some cases in your report as well, and I just want to pull that discussion up. Plaintiff's Exhibit 227 is your report. And if we go to page 71, there's a discussion of a Georgia Supreme Court case in 1868 called Chanceley versus Bailey. Do you see that?
Yes.
And in Chanceley versus Bailey, the year that the 14th Amendment was ratified, the Georgia Supreme Court said, if the late war had been marked merely by armed resistance of some of the citizens of the state to its laws, or to the laws of the federal government, as in the cases of Massachusetts in 1789 and in Pennsylvania in 1793, it would very properly have been called an insurrection, and the acts of such insurgents would have been held as illegal, correct?
Yes.
You also testified on direct about the instructions by Justice Catron that we looked at in Professor Magliocca's testimony, and you called those grand jury instructions helpful in understanding insurrection. Is that right?
Yes.
And just to make sure we're all looking at the same thing, we go a few pages into 752 of Professor Magliocca's appendix. Justice Catron instructed the jury that the conspiracy and the insurrection connected with it must be to effect something of a public nature concerning the United States, to overthrow the government or some department thereof, or to nullify and totally hinder the execution of the United States law or constitution, or some part thereof, or to compel its abrogation, repeal, modification, or change by a resort to violence. That was the instruction that you found helpful, correct?
Yes.
Did you also look at how Justice Chase, not the Chief Justice, the other Justice Chase, defined insurrection in the case of Fries?
No.
If we go to page 834 of Professor Magliocca's appendix, this is a case of Fries from the Circuit Court of the District of Pennsylvania in 1800. Do you see that?
Yes.
If we go to page 841, the court says, on this general position, the courts are of the opinion that any such insurrection or rising to resist or prevent by force or violence the execution of any statute of the United States for levying or collecting taxes, duties, imposts, or excises, or for calling forth the militia to execute the laws of the Union, or for any other object of a general nature or national concern under any pretense, as that the statute was unjust, burdensome, oppressive, or unconstitutional, is a levying war against the United States within the contemplation and construction of the Constitution. Correct?
Yes.
And that also uses this language we've seen earlier about a rising up to resist by force or violence the execution of law. Correct?
Yes.
I just want to finish this line of questioning by asking about your example where you say that Professor Magliocca's definition of insurrection against the Constitution would essentially mean that Section 3 covers any effort to obstruct the mail. Do you remember that testimony?
Yes.
Well, that's your interpretation. That's not something Professor Magliocca ever testified about, correct?
Yes.
Do you remember that when Professor Magliocca gave his definition of insurrection, his definition was a group of persons resisting execution of law by force or threat of force?
Yes.
And do you also recall that Professor Magliocca explained that Section 3 only applies to those who had previously sworn an oath in certain kinds of official capacities?
That was my recollection of this testimony. Yes.
If a person has never been in government and never taken an oath to the Constitution, does Section 3 have anything to do with them at all?
Well, that's a requirement of the offense who, having taken an oath to support the Constitution, thereafter engaged in some kind of activities.
All right, Your Honor, I think this would be a good time to break for lunch.
We will reconvene at 1 o'clock for Mr. Heafy, and then we will finish your testimony, Professor Delahunty, after Mr. Heafy is done, okay?
May I have lunch and speak with my counsel?
You may absolutely have lunch.
But not discuss my testimony?
Under the rules, you're not supposed to discuss your testimony with counsel.
Okay. I do
But
not want that.
we do want you to eat. Okay. Professor Delahunty, I'm still under oath. You're still under oath.
And Your Honor, I just wanted to flag for the court that after Mr. Delahunty's testimony, we'll have just 5 to 10 minutes of sort of evidentiary housekeeping matters, if that's all right.
Yeah, and I want to talk about a few things about the proposed findings, facts, and conclusions of laws.
Thank you. Mr. Delahunty, did you speak with anybody about your testimony since you were last on the stand?
No.
When we talked before lunch, we had just been discussing your testimony that Section 3 is ambiguous. And we'd finished talking about the meaning of the phrase insurrection. So now I want to turn our attention to your opinion about the meaning of the phrase engaged in insurrection. Now, you recall talking about opinions by Attorney General Stanberry.
Yes.
And I believe you called Attorney General Stanberry's opinions good evidence about the meaning of Section 3.
Yes.
Now, at the time that Attorney General Stanberry issued these opinions, that was in 1867, right?
Yes. This is before the ratification of Section 3.
1868 was before the states ratified Section 3, but after Congress had enacted legislation proposing Section 3 to the states, right?
Yes.
Let's pull up Attorney General Stanberry's first opinion, this is on page 788 of Professor Magliocca's appendix, you talked about how the Reconstruction Acts were a statute. So I just want to look briefly at this. The 6th section of the Reconstruction Acts provides, among other things, no person shall be eligible to any office under any such provisional governments who would be disqualified from holding office under the provisions of the 3rd article of said constitutional amendment, correct? So the Reconstruction Acts incorporated fully Section 3 of the 14th Amendment. The applicable language was identical, correct?
I think if you read this, that's what it says. It says, no person shall be eligible to any office under any such provision of government.
Yes, I'm sorry.
Person shall be eligible to any office under any such provision of government, so that's not the language of Section 3. It's over there about offices, state offices, under former Confederate, now provisional governments. So is that?
Well, to be clear, though, this is saying that people would be disqualified from holding office under Section 3. And so when we're talking about engaged in insurrection or rebellion, that phrase was the phrase he was interpreting among others here,
Yes,
correct?
I think, it's fair to say that the text of the statute itself incorporates the jurisdictional provision of Section 3.
Do you recall testifying in your direct examination about official versus individual capacity? And I think the point you were trying to make was that it wasn't totally clear what kinds of conduct were disqualifying in an official capacity versus in an individual capacity.
That seems to be Stanberry's opinion, yes.
I want to look at that discussion in Stanberry's opinion. If we go to page 799 of the appendix, there's a discussion here at the top. All those who, in legislative or other official capacity, were engaged in the furtherance of the common unlawful purpose, or persons who, in their individual capacity, have done any overt act for the purpose of promoting the rebellion, may well be said, in the meaning of this law, to have engaged in rebellion. Do you see that?
Yes.
And then the paragraph after that gives some examples of what might be considered engaging in rebellion in an official capacity. And then later on in that page, at the bottom, Stanberry says, so much for official participation, I now recur to what amounts to individual participation in the rebellion. Do you see that? And that's at the bottom of page 799. If we go to the top of page 799, and really that whole page is about individual participation in rebellion, correct?
I'm not sure.
What page did you say the previous one was?
Well, we just looked at the bottom of page 799.
And then what follows is,
Your Honor, may I approach the witness just to readjust the screen and microphone?
When you lean in, it's getting all that feedback, so let's try to. Does that help, Professor?
yes.
So at the bottom of page 799, Attorney General Stanberry transitions from the subject of official participation to individual participation. Is that correct? And then the following page, page 800, there is a discussion of what it means to have engaged in individual participation in rebellion. And on page 799, Stanberry says it requires some direct overt act done with the intent to further the rebellion. Do you see that?
He says that's a necessary division of bringing the party within the purview of medium. It's not sufficient, he says it's a necessary division.
Well, sir, later in that same passage, he says, but wherever an act is done voluntarily and in aid of the rebel cause, it would involve the person and it must work disqualification under this law. That was Attorney General Stanberry's interpretation, correct?
Yes.
I want to turn to page 804 of Professor Magliocca's appendix and just highlighting that now we're talking about Attorney General Stanberry's second opinion. Do you see that?
Yes.
And if we look at page 815 of that opinion, I just wanted to direct your attention to the second from the bottom paragraph there, where Attorney General says that while forced contributions are not disqualifying, voluntary contributions to the rebel cause, even such indirect contributions as arise from the voluntary loan of money to rebel authorities or purchase of bonds or securities would work disqualification, correct?
Are we talking about the second paragraph?
Yes.
That's what he says.
And then later on that page, he specifically says, when a person has, by speech or writing, incited others to engage in rebellion, he must come under disqualification, correct?
Yes. But here he is talking about those who are subject to disqualification as because of their actions in official capacities, discharge offices
officers who are doing the discharge official duties, not incident to war, like being an ambassador, purported ambassador of the Confederacy to France. Those people are not, in his judgment, subject to disqualification in light of actions such as speech or writing that incite others to engage in rebellion. So here he is talking about action in an official capacity. I don't know if that in his view translates into disqualification for actions done in an individual capacity.
Well, sir, the first sentence of this says that officers during the rebellion discharged official duties not incident to war, but only such duties as belong to a state of peace and were necessary to the preservation of order and the administration of law are not to be considered as thereby engaging in rebellion or disqualified, correct?
I think what he has in mind there is that these are law enforcement officials on the level of constable, let's say, who are keeping peace in some county in the Confederacy. And in keeping the peace locally, they're engaging in official duties, but not official duties incident to war. So that's the class of persons in this.
Correct. In the first sentence, he's saying this is a class of persons that are not disqualified. And in the second sentence, he says, when a person has, by speech or writing, incited others to engage in rebellion, he must come under disqualification, correct?
That to refer to incitement by speech or writing in the discharge of official duties.
But nowhere in that sentence does it say in the discharge of official duties, correct, sir?
If you read it in context with the preceding sentence, that strikes me as clear indication.
That's your interpretation, correct?
It is.
In your report, you didn't discuss any of the pre-Civil War treason cases about incitement, did you?
No.
This is page 44 of Professor Magliacca's appendix, and here we're looking at charge to the grand jury treason from the Circuit Court in the Eastern District of Pennsylvania in 1851. Do you see that, sir? If we look at page 46, and by the way, this is from Judge Kane charging the grand jury. Judge Kane says, there has been, I fear, an erroneous impression on this subject among a portion of our people. If it has been thought safe to counsel and instigate others to acts of forcible opposition to the provisions of a statute, to inflame the minds of the ignorant by appeals to passion and denunciations of the law as oppressive, unjust, revolting to the conscience, and not binding on the actions of men, to represent the constitution of the land as a compact of iniquity, which it were meritorious to violate or subvert, the mistake has been a grievous one. Do you see that? And do you see at the end of that paragraph, Judge Kane instructs the grand jury that successfully to instigate treason is to commit it.
Yes.
But you didn't consider that in your report in this case, correct?
Because it's about treason, and in particular about levying war. So if this case is relevant, I think it's relevant to a part of Section 3 that does not appear to be an issue, and that is the part that refers to aid or comfort to the enemy. So that doesn't really speak to the meaning of insurrection or insurrection against the Constitution.
Your opinion. Sorry, go ahead.
Show me where it talks about insurrection other than in the context of treason. Could we go back to the first page?
Let me just ask you a question. Is it your opinion that incitement was enough to have levied war against the United States for purposes of the treason clause, let me finish, but was not enough to have engaged in insurrection under Section 3? Is that your opinion?
I don't know the answer to your question.
I want to move to the subject of self-execution that you testified about on direct examination. You know that states can enforce federal constitutional provisions through their own procedural rules, correct?
Yes.
That would include, for example, Section 1 of the 14th Amendment, right?
In Massachusetts.
Well, certainly a state could pass legislation providing remedies for violations of due process or equal protection, correct? There's nothing unconstitutional about that.
Not that I can see, no.
You're not an expert in Colorado election law, fair to say?
No, that's very fair to say.
And you're not here to offer an opinion as to whether Colorado law grants a right of action to enforce federal constitutional qualifications in presidential primaries.
I have not read any Colorado law, statutory law.
Let's just briefly discuss Griffin's case. So Griffin was convicted of a crime in Virginia, is that right?
Yes.
And he was convicted of a crime by a state court judge who presumably was disqualified under Section 3.
Very likely. Yes.
So then Griffin brought a federal habeas petition in federal court, arguing that his conviction should be overturned because the judge was disqualified under Section 3.
Yes.
And on direct examination, you said that Griffin's case had kind of three separate holdings. Do you recall that?
Yes.
One of the holdings denied habeas relief to Griffin on the basis of the de facto officer doctrine. Do you recall that?
Yes.
And as I understand it, the de facto officer doctrine essentially said this judge was in fact in that office at the time, even if perhaps not lawfully so, and we're not going to allow a collateral attack on the conviction of someone who was convicted by a de facto judicial officer. Was that the reasoning?
Essentially, yes.
And the court also denied relief based upon the scope of habeas relief available under federal law, right?
Yes.
So just so we're all clear, Griffin's case did not involve a party invoking state procedural rules to enforce federal qualifications, correct? Do you know what year Griffin's case was decided?
I think it was decided in late July 1869.
What was the status of Virginia in 1869?
Well, there is another Attorney General opinion. I think it is the second opinion of Stanley, but I have to confirm that discusses the powers of states not getting committed really to the Union. And the tenor of that, maybe clear language, is to the effect that the powers of the Union Army and military are very circumscribed, but they are part and parcel of the provisional government of the state, and the provisional government has basically all powers that an unreconstructed state would have, barring those that are expressly conferred on military.
But Virginia was under federal military occupation in 1869, right?
I don't know. I think so, but I have not confirmed that.
And in fact, Virginia didn't get readmitted to the Union until 1870. Do you know that?
No, but I will take that representation. So that
I want to turn to your opinion that Section 3 does not cover the president. Oh, well, the president is not an officer of the United States. That's your opinion, correct? Before this case, before you became an expert in this case, you had previously suggested that Section 3 does cover the presidency. Do you remember that?
what I said and what I think you're referring to was that there is support for the view that it does not, jurisdictional, because I didn't use that term, but Section 3 does not include the president as subject to the section.
Can you move the microphone?
You addressed this issue in your op-ed in the Federalist in August of this year, correct? And in that op-ed, you said,
May I, hold on, just say, address this issue in his sense, St. Massey, basically to take it off the table by saying I did not really want to discuss the issue any further.
understood. And in that portion of your article, you said that although Section 3 does not explicitly refer to presidents or presidential candidates, comparison with other constitutional texts referring to officers supports the interpretation that it applies to the presidency too. Were those your words back in August?
Yes.
Your article from the Federalist in August of this year certainly didn't argue that the president was not covered by Section 3, right? You wrote that article in August of this year before you were hired by Donald Trump as a paid expert in this case, right?
Yes.
Since the time you wrote that article in the Federalist, you've been paid about $60,000 by Donald Trump for your work in this case? I want to pull up the language of Section 3 just so we're all clear on offices and officers. And let's start with offices. So, no person shall hold any office, civil or military, under the United States if they are disqualified and have not received amnesty, correct? You agree that the presidency is an office under the United States, don't you?
I took no position on that. That is disputed among scholars. I think Professor Lash does not believe that that language applies to the presidency as an office. Other scholars, maybe the preponderance, think it does. It is the subject, that language, of the colloquy that I think the judge questioned about earlier, the colloquy between Senator Beverly Johnson and Senator Marijuana. So I don't take a position on that, whether the presidency as an office is covered or not.
So you're not going to tell us today whether the presidency is an office under the United States?
That's right. I haven't formed a valid opinion about that.
Well, sir, you know that the Constitution repeatedly refers to the office of the presidency, don't you?
That's one of the reasons I would be inclined to think that that language does apply to the office of the presidency.
You would be inclined to that view, or you don't know?
Well, they're consistent statements.
Let's look at Petitioner's Exhibit 235. This is just the U.S. Constitution. And Article 2 is the portion of the Constitution that defines the powers of the presidency, right? Or at least one of them? And the executive branch?
Well, that's the president of the United States with the executive power. Does the president have powers outside of Article 2?
No, I think I'm just saying that Article 2, at least in part, sets out the powers of the executive branch, correct?
Yes. I'm trying to think whether Article 7 refers to the president or the powers of the president to respond fully to your question.
Understood. I just want to highlight a little bit of language here in Article 2. In Section 1, it says that the president shall hold his office during the term of 4 years, right?
Yes.
And it refers to eligibility for the office of president
Yes.
and being eligible to that office.
Yes.
And it talks about the removal of the president from office and the duties of that said office.
Yes.
And the president, in fact, before he enters on the execution of his office, he has to take his oath, right?
That's right.
You know that the 12th Amendment also refers to the presidency as an office.
Yes.
And despite all that, you're not going to offer an opinion that the presidency is an office under the United States?
No, I'm not.
Well, let me ask you this. You agree it was well understood that Section 3 would not allow Jefferson Davis to become the president of the Union after the Civil War unless he got amnesty, right?
Well, if the language that we're discussing in Section 3, the disqualification or liability language, includes the office of the presidency, then Jefferson Davis would clearly have been disqualified from holding that office because, as I said, from Mississippi and perhaps another connection, he had taken the Article 6 oath to support the Constitution.
Correct. And you understand that after the Civil War, it was incredibly well understood that Jefferson Davis could not be the president of the Union unless he received amnesty, right? You recall seeing some of that evidence?
It was well understood, but there was yes, certainly was barred on the side. There's no question of that. And this was the bargain that Senator Johnson raised, and Senator Lott sought to allay by pointing to the liability of disqualification clause.
And that colloquy that you're referring to,
Yes.
if we go to page 477 of Petitioner's Exhibit 144, this colloquy between Mr. Johnson and Mr. Morrill is what you're referring to?
Yes.
And you in your report said that this colloquy may tend to show that the presidency is an office covered by Section 3, right?
An office covered by the disqualification or liability language of Section 3.
And you would agree that in the debates about amnesty after the Civil War, one of the main arguments against blanket amnesty was that it would be absurd to allow Jefferson Davis to be the president of the United States, and if you granted amnesty for everybody under Section 3, then Jefferson Davis would become eligible to be president. Have you seen all that historical evidence?
Well, there may have been people who thought that, but they would have been wrong if the office of the presidency was covered by the language that Senator Morrill proposed. Whatever they thought, he would have been disqualified.
Yes, and
Because he falls within the jurisdictional element of Section 3, which is having taken an oath to support the Constitution.
so even though everybody at the time knew that Section 3 disqualified Jefferson Davis to be president, you don't think that's good enough evidence to take a position as to whether or not the presidency is an office that is covered by Section 3?
Because this is a matter of active scholarly dispute. Professor Lash and Professors Blackman and Tillman do not think that the language which you said is your office comprehends the office of the presidency.
And they also don't think it's enough that the presidency is referred to it as an office about a dozen times in the Constitution? Let's talk about oaths. I believe you testified on direct that you thought there's a difference between an oath to support the Constitution of the United States and the president's oath. Do you recall that testimony?
Yes.
And I believe you said that the president's oath to preserve, protect, and whatever else it says isn't an oath to support the Constitution, right?
Obviously, it's actually a different oath, and it's in a different article of the Constitution as well.
Okay, it's preserve, protect, and defend the Constitution, right? That's what the president has to do?
That is, he is required to take that oath, and having taken it to carry that.
And they use different words, but you would certainly agree with me that preserving, protecting, or defending the Constitution of the United States as a practical matter includes an obligation to support it, right?
I don't think it is about what as a practical matter. It requires to support the Constitution as a practical matter. Sure, but we're not talking about practical matters. We're talking about the actual language of the Constitution. The actual language of Article 6 is palpably different from the oath clause in Article 2. Palpably different.
And sir, are you going to take the position, well, strike that. Preserving, protecting, and defending the Constitution of the United States may not be limited to supporting it, but certainly includes supporting the Constitution, right?
As a practical matter, yes, but again, I don't see the real relevance of that because constitutional language is crafted carefully and precisely so as to achieve the intended objects. And I do not believe that the framers of Section 3 were careless in their draftsmanship. It may be that there are some formulations of the Article 6 oath, or its equivalent, that vary linguistically, slightly, but there's a palpable difference between the language of the Article 2 oath and the language of the Article 6 oath. I think that linguistic difference, which is a substantial one, supports the view that the President is not comprehended under the disqualification language of Section 3 because he does not take an oath which members of Congress do to support the Constitution. He takes a different oath and has ever since George Washington was inaugurated in 1788. And I think the framers of the Section 3 understood that perfectly well.
Sir, we talked about dictionaries earlier, and you testified on direct that in some of the historical research you've done in the past, you've looked at a dictionary by Samuel Johnson. Do you remember that?
That's my recollection. I did, yes.
And you cited Samuel Johnson because that dictionary in the late 1700s was considered kind of one of the gold standards for lexicography and definition, right?
Yes, maybe not unique, that dictionary of English language.
All right, so let's pull up Petitioner's Exhibit 280. This is Samuel Johnson's 5th edition, which I will represent to you is from 1773. And I want to look at how Samuel Johnson defined defend, that word that appears in the Article 2 oath, okay?
Yeah.
Defend, to stand in defense of, to protect, to support. Do you see that, sir?
Yes.
I want to go back to our Section 3. Your position is that you're not going to tell us whether the presidency is an office under the United States, but you know that the president is not an officer of the United States. Is that your testimony?
I am very confident that the president, for this purpose, is not an officer of the United States, and I rest that position on the occurrence of that term, that specific term, that exact language, in other parts of the Constitution and judicial interpretation of that language in other parts of the Constitution from up to the time of Chief Justice John Roberts in the free enterprise case. There's a consistent body of judicial opinion from the Supreme Court and other lower courts concerning the meaning of officer of the United States elsewhere in the Constitution, and some of that case law is around the time of the ratification, discussion of ratification of Section 3.
Okay, sir. And you talked about some case law on direct examination as well, and I believe that you said that some of those cases were about the Appointments Clause, which you said was the anchorage of the meaning of the phrase officer, right?
Yes.
Let's look at the Appointments Clause. Our Constitution again, on page 7. The Appointment Clause says that the President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, correct?
Yes.
And the President can't appoint himself, right?
No. That's because he's not an officer of the United States.
Well, he's certainly not an other officer of the United States, right?
Well, not being an officer of the United States, he can't be another officer of the United States.
Right, but if we're talking about the Appointments Clause, and the Appointments Clause is talking about other officers of the United States, clearly the Appointments Clause couldn't cover the President, even if he was an officer, right?
Well, let me refer again to Chief Justice Roberts' opinion in the free enterprise case, where he explains the language that's issued right now in the Appointments Clause as indicating this, that the Constitution establishes quite clearly distinction, it's a fundamental distinction in the Constitution between those who are elected to their offices, like the President, and those who are appointed to their offices, like the Secretary of State or the Chief Justice or other officers of the United States. And that's why that fundamental constitutional distinction, which is reflected here between elected and appointed, that's recognized and established in the case law.
All right, so let's look at that. I want to look, let me ask you this first. You know that President Trump has previously argued that he is an officer of the United States, correct?
I do not know that, but if I wanted a constitutional interpretation of that language, he would not be the first person to tell me that.
Fair enough, but let's look at it anyways. Petitioner's Exhibit 287. I'm showing you President Donald J. Trump's memorandum of law in opposition to the people of the state of New York's motion for remand. Do you see that on your screen? Okay, and the way this case came up is that there was a criminal prosecution of President Trump that then got removed to federal court. President Trump tried to remove it to federal court, and then the district attorney of New York tried to remand it back to state court, right?
I'll take the word for it.
Okay, if we go to page 8, legal argument. Point 1, the president is an officer of the United States who can remove cases to federal court. Do you see that? Later on, and this is page 2 of the motion itself, numbered page 2, there's a citation to Josh Blackman and Seth Barrett Tillman. And do you imagine that those are the same scholars that you had cited in your direct testimony?
Yes, they're the same.
And President Trump says, while this argument that elected officials, including the president, are not officers of the United States, has been advocated by these professors for some time, to our knowledge, it has never been accepted by any court. Do you see that?
Yes.
And if we go to the next page, well, actually, at the bottom of this page, there's a footnote 1, and they're citing some articles, and then the footnote continues on page 2, and President Trump says, to be clear, we mean no disrespect to either of these fine academics, but their views on this matter are idiosyncratic, c.e.g. our next president, at 5 through 6, collecting the contrary views of numerous scholars, and of limited use to this court. Do you see that?
Yeah.
Did you know that this brief also specifically addresses the free enterprise case that you were just talking about?
No, I have not read the New York lawyer's brief.
Well, on the next page, page 4, there's a citation to Free Enterprise Fund, and that's the case you were just referring to, right?
Yes.
And it says that case addresses the president's removal power under the Article 2 Appointments Clause. And then it says later, it is clear that the Supreme Court was not deciding the meaning of officer of the United States as used in every clause of the Constitution, let alone in every statute of the United States Code. Rather, the court was simply describing the meaning of other officers of the United States as used in U.S. Constitution, Article 2, Section 2, Clause 2. Do you see that?
Yes.
And then that paragraph goes on to say, obviously the president cannot appoint himself, and so other officers of the United States, as used in Article 2, Section 2, Clause 2, must be a reference to non-elected officials, right? And then President Trump says, this stray line in Free Enterprise Fund says nothing about the meaning of officer of the United States in other contexts, such as the relevant context this court must consider here, correct?
Yes.
I want to take us back to the 19th century now.
Did you want me to speak to this?
No, your counsel can ask you questions about that if they'd like. Let's go back to the 19th century. Petitioner's Exhibit 144 again, Magliocca's materials. And we're going to go back to Attorney General Stanberry's first opinion.
Yes.
You're aware that he also addresses officers of the United States, correct?
In the statutory context.
Yeah, in the context of the Reconstruction Act's applying Section 3 disqualification.
Yeah.
And Attorney General Stanberry says, this brings me to the question, who is to be considered an officer of the United States within the meaning of the clause under consideration? Here, the term officer is used in its most general sense and without any qualification as legislative or executive or judicial. And I think, as here used, it was intended to comprehend military as well as civil officers of the United States who had taken the prescribed oath, correct?
Yes.
And did you know that Attorney General Stanberry also addressed the meaning of officers in his second opinion?
Yes.
Page 811, excuse me, page 814, officers of the United States. As to these, the language is without limitation. The person who has at any time prior to the rebellion held any office, civil or military, under the United States and has taken an official oath to support the Constitution of the United States is subject to disqualification. Do you see that? So here, Stanberry isn't drawing a distinction between officers and those who hold offices, correct?
Not that I can see.
Did you know that Attorney General Stanberry also referred to the president as an officer?
I said that, though he wasn't there purporting to interpret the language of Section 3. My recollection is that he said that the military governor of not yet readmitted state, if he usurped powers that were not his, would be placing himself on a higher footing than the president, who is, if I remember the language, not to be considered, who is merely an executive officer of the United States. I think that's what it says. It doesn't appear on the screen, but I think we have to read what Stanberry is talking about here in construing statute in light of what he says elsewhere.
Yeah, and your opinion, or what you just said, you quoted it spot on, and that was from this same second opinion of on the Reconstruction Acts, correct?
Yes.
Andrew Johnson was president when the 14th Amendment was ratified, right?
Yes, he issued a proclamation that had been ratified.
And he also issued other presidential proclamations, correct?
He did.
And in some of those proclamations, Andrew Johnson referred to himself as the chief executive officer of the United States.
He referred to himself as the chief executive officer of the United States.
Do you know whether other presidents during the 19th century were referred to as the chief executive officer of the United States?
It was a common way of referring to the president, and may still be now.
In the 19th century, it was a common way to refer to the president, to refer to him as the chief executive officer of the United States. You would agree with that?
A common way, not common in connection with the interpretation of the Appointments Clause, however. And indeed, the chief executive officer of the United States is a different term, colloquially, from the term officer of the United States, as used in various places in the Constitution, principally Article 2's Appointments Clause. So I don't consider that evidence of it's not really very relevant, if it's relevant at all, which I doubt, to the interpretation of the Constitution in any of its parts that uses the term officer of the United States.
So
I think that the focus needs to be not on how officer or officer of the United States even is understood in statutory context, in official proclamations, in colloquial usage. The question before the court is, how is it understood for purposes of the framing, ratification, and later understanding of Section 3 legal terms and ordinary uses of language, and not simply be mapped on to the constitutional language.
You don't think it was relevant in interpreting the phrase officer of the United States as used in Section 3 in the 1860s to look at what people in the 1860s thought officer of the United States meant?
Not given the language of the original Constitution of 1788. No, I do not think it is particularly relevant at all. It's the legal term, constitutional term of art. Let me give you an
And-
example of what I mean.
Well, let me ask you a question, sir, and then you can answer my question. So you wouldn't think it was relevant that Presidents Jefferson, Jackson, Van Buren, Harrison, Polk, Taylor, Fillmore, Buchanan, Lincoln, Grant, and Garfield were all also referred to as the Chief Executive Officer of the United States?
I don't. Let me give you an example.
I'm just going to, that was just a yes or no question. If you want to expound, I'm sure your counsel can follow up on it.
Particularly relevant.
And therefore, you didn't look at any of that historical evidence in your report,
The
correct?
Constitution says what it says, and you interpret one clause of the Constitution in connection with other terms that use the same language or extremely close.
Okay, but you would agree with me that the original Constitution was ratified roughly 80 years before Section 3 of the 14th Amendment, right?
Right.
Okay, right now we're in the 117th Congress. Do you know which Congress was the Congress that enacted legislation proposing ratification of Section 3?
It was proposed in 1866.
And what number Congress was that?
I don't remember that.
You're not aware that it was the 39th Congress, one of the most famous Congresses in American history, that proposed Section 3?
Well, I'm grateful to be reminded.
And so you also didn't think it was relevant that the 39th Congress repeatedly referred to the president as the Chief Executive Officer of the United States?
Again, unless, no, I don't think it's particularly relevant. I mean, may I finally give an example that I mean to underscore my claim that it's not relevant?
Sure.
Article 2 says that the Senate shall advise and consent to presidential nominations to certain offices, and the Senate shall advise and consent to treaties. Well, if you took those words, advise and consent, in their ordinary meaning, outside the context of the Constitution, then the Senate would have to consent to every treaty and consent to every presidential nomination. The Senate doesn't always consent to treaties or nominations, right? So I deduce from that that the term advise and consent was a term of art as used in the Constitution. My recollection, I never studied this deeply, but my recollection is that the term advise and consent was used as a term of art in English law, and then entered our Constitution in 1788 with the understanding that that was the legal meaning of advise and consent. Not clearly not the only, not an understanding of the term advise and consent that those words had in common acceptation.
And because of your view about constitutional interpretation and methodology, you didn't think it was relevant to see how the 39th Congress that enacted the 14th Amendment used the phrase officers of the United States, correct?
Not particularly relevant, no.
And so if I were to show you 10 pages from the Congressional Globe of the 39th Congress that repeatedly referred to the president as an officer of the United States again and again and again, and these were the very same people who enacted Section 3 of the 14th Amendment, you wouldn't think any of that was relevant, would you, sir?
They're proposing the language of Section 3 against the backdrop of the Constitution that had been in existence for 80 years, and as that constitutional language would have been understood even before it existed.
So there's some sort of technical term of art meaning in the phrase officers of the United States that was different from the way that everybody was actually using those phrases in public during the ratification or during Reconstruction. That's your testimony?
No, I don't want to characterize it that way.
All right, I have no further questions. Thank you.
My questions are going to be less than that, Your Honor.
I know, but I can answer.
That's non-negotiable 5 minutes. I understand, Your Honor.
The floor is yours.
Thank you, Your Honor. Professor Delahunty, I'm going to ask you to grab that microphone and get it close to you there. So you were asked some questions about your opinion with respect to the payments you're receiving in this case, correct?
Yes.
Okay. Do you remember having a conversation with me about a version of the 14th Amendment that was introduced into the House of Representatives by Representative McKee?
Yes.
Okay. And you remember I said, and that particular version said, specifically spoke to the portion of the 14th Amendment involving the first phrase, the one involving under the office under the United States. And that first version introduced by Representative McKee, specifically said, specifically included the President and Vice President of the United States. You remember that?
Yes.
And you remember I was pretty enthusiastic about that provision and thought that that should be included in your expert report. You remember that?
Sure.
I was very enthusiastic.
Yes.
And did you include it in your expert report?
No.
And why not?
Because I thought it was relevant to the use of the term officer of the United States in disqualification language. I thought it just wasn't really.
And at the time, I'm sorry, and at the time you refused to include it, did you know that you were receiving compensation for putting together this report?
I'm not sure that I don't know the answer every time. I don't know the answer.
Okay. Did you understand that you were getting paid for your work by President Trump?
Yes.
Okay. Now, do you earn your living as a testifying expert witness?
No.
Do you have plans to market yourself as a testifying?
Absolutely not, no.
No further questions, Your Honor.
Mr. Delahunty, you are released. Thank you so much. So I think that there was some additional evidence that the petitioners wanted to offer. Is that correct?
Yes, Your Honor, we've, I think, reached agreement on each side has a few more things we would like to put in to make sure we can complete the record. And I think they have 3 things. We have 3 documents and a handful of videos, total running time less than 10 minutes. Would you like to do that now?
Yeah, let's
Okay,
take care of everything.
great. And first, and then a couple other just quick notes. Exhibit 78 is the findings of the final report of the January 6th Select Committee that we would like to submit. We mentioned we were going to reduce the size of those findings, even ones you deemed admissible, because evidence came in through other ways. Our plan, if it's okay with Your Honor, is to use the weekend to look at the transcripts and then submit, when we submit the final exhibits to you, the shortened version of that Exhibit 78, if that's okay with Your Honor.
Yeah, that's fine. When you do so, will you just make sure that you make a notation as to whether the interveners agree that, I know that they object to them all, but that they agree that those are ones that I've otherwise held to
Yeah,
be civil.
yeah, great. We will do that.
And I'll be with Mr. Messer, all the arguments you made about January 6th.
Secondly, just a cleanup on the transcript. When we qualified Dr. Simi as an expert, I think the transcript reflects his testimony. He was admitted as an expert on political extremism, excluding a bunch of specific things, and I think it should say including. I offered him as an expert on political extremism, including how extremists communicate, his interpretation of January 6th vis-a-vis his expertise in extremism and extremism communication. We just want to be clear that that second phrase was part of what he was qualified as an expert on.
So would you say the transcript, do you think it was just mistranscribed, or did you misspeak, or?
I think you misspoke, Your Honor.
Okay. I'm sure I meant to say including.
Okay, great.
Because I wouldn't exclude the very things he was going to testify about.
Yeah, we just wanted to clarify. And then there are a few portions of admitted documents that Your Honor hasn't seen. Our proposal would be just to call those out in proposed findings rather than show them to you right now, but we're happy to show them to you right now if you want to see them before we submit the proposed findings. But really welcome guidance from Your Honor.
Didn't really follow. So there's,
A few portions of some admitted documentary evidence that we have not shown on the screen. We would like to reference those portions in the proposed findings of fact. But because it's admitted evidence, our proposal would be just to reference it in the findings of fact rather than show you the documents now. But if you'd like, we can have a slideshow and look at the documents.
if what you want to say in the proposed findings of fact conclusions of law is from an admitted exhibit,
Yeah.
we just haven't talked about, I consider that to be evidence that's been admitted.
Great, thank you. That was our understanding. Thank you, Your Honor, for the clarification. So now let me turn to the 2 documents that we would like to move for admission. Again, these are not objected to. And just to make it move and be a little more interesting, I'll put the first page of the document on the screen, but I'm not going to walk through the whole document. The first is Exhibit 30. Give me 1 second, Your Honor. You would think by Friday we'd have this figured out, so my apologies. All right, there we go. The first, Your Honor, is a
Very short.
in fact, we moved the admission of the artisanal flowers. Am I driving the output right here? There we go. I'm just glad I made it this long. Thank you very much. First is Exhibit 30. It's a Government Accountability Office report on the Capitol attack, and we're mainly offering it for, there's a table on page 24 that will reference our findings of fact. The next is Exhibit 157, which is the readout from the teleprompter that Donald Trump saw during the eclipse speech. And so this differs from the actual speech in ways that we'll discuss, but this is what was on the prepared remarks for Donald Trump. And if you see at the bottom, it's an official government record from the General Accounting Office. You'll see on the bottom left. Turning to, so we move for the admission of Exhibit 30 and 157.
Is it really, no, it has been stipulated does President Trump object to 157?
Your Honor, we don't. We're going to argue its lack of relevance with respect to weight, but I guess both houses are following the rule of the big bucket of evidence. And so under that, we'll argue it has little, if any, bearing, but as far as its authenticity and to the extent the court wants to accept its relevance, we don't object.
Okay, so how about the Colorado Republican Party? Any objection to those two exhibits?
No objection.
Okay, so 30 and 157 are admitted.
Thank you. Now we'll turn to the videos, Your Honor. The first is Exhibit 58.
I mean, when you have 15,000 people marching up, and you have hundreds and hundreds of people, and you have 2 or 3 border security people that are brave and great, and don't forget, we don't let them, and we can't let them use weapons. We can't. Other countries do. We can't. I would never do that. But how do you stop these people? You can't. There's no. That's only in the Panhandle you can get away with that stuff. Only in the Panhandle.
And I'll just go through all the video exhibits and move to the admission at the end, Your Honor, if that's okay. The next is Exhibit P62, or Exhibit 62, plaintiff's Exhibit 62. What, actually?
What really drives me crazy is 12 more years. Because they're doing some really bad things in 2016. Let's see what happens. Because they're doing some really bad things. We have to be very careful because they're trying it again with this whole 80 million mail-in ballots that they're working on. Sending them out to people that didn't ask for them. They didn't ask, they just did. And it's not fair, and it's not right, and it's not going to be possible to tabulate, in my opinion, just my opinion. We have to be very, very careful. And you have to watch, every one of you have to watch. Because bad things happened last time with this line in our campaign, and that goes to Biden, and that goes to Obama. And we have to be very, very careful. We have to be very, very careful. And this time they're trying to do it with the whole post office scandal, letter at the post office. You can see them setting it up. But see, under their plan, when they send these ballots, you don't have to want to vote. You get the ballot, and then they have harvesting. They get guys that go, do you want to vote? No, I'm not really going to have a ballot. Right there. Who's it for? Sleepy Joe Biden. I'll put it here. Okay, can I have it? And they'll take it. Think of it. They'll be sending it. They'll be dumping them in neighborhoods. There'll be people that will be picking them up. They'll be bribing. They'll be paying off people to grab some. This is going to be one of the greatest scams, and it's common sense. This has nothing to do with politics. It's common sense. Anybody, you don't have to know politics. They're going to mail out 80 million ballots. It's impossible. They have no idea. Who's mailing them? Mostly Democrat states and Democrat governors. But supposing they don't mail them to Republican neighborhoods. That means they're not going to get them. So they're going to complain, and the election's going to be over, and then they're going to complain, and then they'll say, oh, well, we didn't get it. In the meantime, you might lose the election. This is the greatest scam in the history of politics. They never let that happen again. But now they're doing something that in a certain way is more dangerous because it's more effective. They spied on my campaign. You know what they found? Nothing. But this is big stuff. This is stealing millions of votes because if they give it a fair call, we're going to win this election. The only way they can take this election away from us is if this is a rigged election.
And, Your Honor, this was on August 24th, 2020, and you can see at the bottom a speech at the Republican National Convention. The next video.
Sure, can I just make a comment? Your Honor, we did not object to this as statements from President Trump. What I would ask, and I'll just go through these one by one, is that we nonetheless have a right to introduce the entire speech, if necessary, because there's a few editing. There may have been a former Colorado Secretary say wild applause that is in the background during that convention.
You want to make sure that that's part of the record.
Exactly. But yeah, we may want to include the entire or additional portions.
And we, of course, have no objection to
That's
that.
fine.
Yeah. And the first one we watched was a May 8th, P58 was a May 8th, 2019 speech in Florida Panhandle. The next is P64, plaintiff, or petition to exhibit 64.
Real quickly, when we go in this election, when you come in here today for a peaceful transfer of power after the election, and everybody's been writing in Louisville, there's been writing in many cities across this country, red and through so-called red blue states, will you commit to making sure that there is a peaceful transfer of power after the election?
Well, we have to see what happens. You know that I've been complaining very strongly about the ballots and the ballot searches, actually.
But people are right. Do you commit to making sure that there's a peaceful transfer?
We want to have rid of the ballots, and we'll have a very transfer. We'll have a very peaceful. There will be a transfer, frankly. There'll be a continuation. And the ballots are out of control. You know, and you know who does it better than anybody else? The Democrats know it better than anybody else.
And this was, P64 was on September 23rd, 2020. Our next video is P67 from November 1st, 2020 in Michigan. And this speech is referring to the Trump train with a bus. I can show the setup video that Trump had retweeted. If you'd like, Your Honor, this was the truck surrounded the Biden bus on the Texas interstate. The Trump retweeted the video.
Have I seen that?
Yes, but let me show it. It's P71. We'll start with that. So this is a tweet. This is a video that Trump retweeted.
3, 2, 1, go! Welcome to the breaking law. Yeah. Breaking law. To the breaking law. Yeah. Breaking law. To the breaking.
Well, I missed what was actually happening, so thank you.
You're welcome. And so, if you recall, he retweeted that video saying, "I love Texas," was on top. And then this is a video in Michigan shortly after this event where he talks about this event. It's exhibit P67.
This is something, you see the way around people that, you know, we're protecting his buses. So it's about, and hundreds of cars, Trump and the American flag. That's what you see, Trump and the American flag. Do you ever notice when you see the other side? I don't even see much of the other side. You don't see any, they have no spirit.
The next video is from Miami, Florida, October 23rd, 2015, petition exhibit 127.
The C job, the A job, what do we do? And we gave it the A+ job, and we built something that we love. We built something that we love. Really love. And what happened? I'll let them get out. Go ahead, get them out. See, the first group, I was nice. I'll pick your time. The second group, I was pretty nice. The third group, I'll be a little more violent. And the fourth group, I'll say, get the hell out of here!
The next video is petition exhibit 134 from a CNN town hall. We'll provide the date shortly. I don't have that on my notes.
But when it was clear to you that they were not being peaceful, you saw them rushing the Capitol, breaking windows, they were hitting officers with flagpoles, tasing them, beating them up. When it was clear they weren't being peaceful, why did you wait 3 hours to tell them to leave the Capitol? They listened to you like no one else. You know that.
They do. I agree with that.
So
But
why did you tell them to leave?
Nancy Pelosi and the mayor are in charge. I assume they were able to do their job. They weren't.
But
And-
Pelosi's not in charge.
And, Your Honor, Mr. Murray informed me this is from May 10th, 2023. And our last video is from a August 9th, 2016 speech in Wilmington, North Carolina. 159.
Hillary wants to essentially abolish the Second Amendment. By the way, if she gets to pick her judges, nothing you can do, folks. Although the Second Amendment people, maybe there is, I don't know. But she said the other day she short-circuited. Hey, can you imagine if I said that I short-circuited?
And, Your Honor, it goes on, but the portion that we wanted to introduce was the portion on the Second Amendment piece. So those are the videos that we'd like to move into evidence. Petitioners exhibit 58, 62, 64, 67, 127, 134, and 159.
Any objections, Mr. Hester?
Your Honor, for the record, no one's had objections on relevance, but for the standards before this court, we recognize any of those objections go to weight. We're not going to dispute the authenticity or the admissibility in that sense, Your Honor.
Okay. The Republican Party?
No objections.
Great. So 58, 62, 64, 67, 127, 134, and 159 were admitted? And had 71 already been admitted, the Biden last one?
Yes, it had already been admitted. And with that, subject to submitting the revised Exhibit 78, which is the findings from the January 6th committee, I think that's the evidence that we plan to present in this hearing. Thank you very much, Your Honor.
Thank you, Your Honor. We have 3 additional exhibits that I believe petitioners have agreed to the admissibility of as well. First is the full video exchange for the presidential debate involving Proud Boys. So we'll play that very briefly.
Okay.
Should be 1083, please.
Do we have an exhibit number for this?
That's 1083, Your Honor.
Other members of this group, you have repeatedly criticized the Vice President for not specifically calling out Antifa and other left-wing extremist groups. But are you willing tonight to condemn white supremacists and militia groups and to say that they need to stand down and not add to the violence in a number of big cities, as we saw in Kenosha and as we've seen in Portland?
I would say almost everything I see is from the left wing, not from the right wing.
But what are you saying?
I'm willing to do anything. I want to see peace.
Do it, sir.
Do it, say it. You want to call him? What do you want to call him? Give me a name. Give me a name.
White supremacists and white supremacists.
Stand back and stand by. But I'll tell you what. Somebody's got to do something about Antifa and the left, because this is not a right wing problem. This is a left wing. This is a left wing.
Antifa's an idea, not an organization.
Your Honor, I don't mean to interrupt this argument. But we don't need to listen to anymore. It's for that relevant part that we had there, but it'll be the entire, that portion of the video. Next is a transcript from this same debate. This is the full transcript. We're only seeking to introduce it for purposes of the portion of that Proud Boys, I'll call it Proud Boys exchange, that you just saw. And that's Exhibit 1080. And then lastly, there's a transcript of President Trump's remarks the day after. That's Exhibit 1081, before Marine One departure. We're not able to locate a video. I'm not really sure it exists.
The day after what?
The day after the Proud Boy debate exchange. And if you could scroll down a little bit, please. Okay. And the question is, Mr. President, can you explain what you meant last night when you said that the Proud Boys should, quote, stand back and stand by? The President. I don't know who the Proud Boys are. I mean, you'll have to give me a definition, because I really don't know who they are. I can only say they have to stand down, let law enforcement do their work. Law enforcement will do the work more and more. As people see how bad this radical, liberal, democratic movement is and how weak, the law enforcement is going to come back stronger and stronger. But again, I don't know who Proud Boys are. But whoever they are, they have to stand down, let law enforcement do their work. And then it goes on a little bit, but that's what we'll be seeking to introduce, or we seek to introduce as well. And that's Exhibit 1081. And with that, Your Honor, we rest with respect to our evidence as well. While I have the podium, I know that there's a standing order or request from the court within 2 days of the close of evidence to provide arguments to whether 113 has to be decided within 2 days. I believe we've discussed that, but I just, for a housekeeping standpoint, want to point that out. And I think that was your order of October 2nd, which was about a lifetime ago. I assume we have resolved that, but I at least want to draw it to your attention from a formal standpoint.
Okay, so 1080, well, first of all, did petitioners object to 1081 and 1083?
No, Your Honor.
Republican Party?
We do not object.
Secretary of State?
No.
Okay, so 1080, 1081, and 1083 are admitted. On the issue of section 113, the hearing is not concluded. It will be continued till oral arguments on November 15th. I think it was at 3 o'clock, from 3 to 5, or not for closing arguments, from 3 to 5.
I believe that's correct, Your Honor.
And everybody believes that that's enough time to conclude the closing arguments?
I don't know if there's ever enough time, Your Honor, but I mean, I think both counsel are prepared to make their case with an hour's time allotted to them. At least we are. I assume the sage and concise counsel on the other side are. We will be.
Okay, so on the proposed findings of fact, which are due on November 8th, just a few comments. All proposed findings should have cites either to the record or to the law. If possible, the board would appreciate receiving just full transcripts for the days versus clips of what's being cited. So if that can be arranged, that would be helpful. This is specifically to you, Mr. Kessler. Can you please put your citations in the text and not in footnotes?
Yes, Your Honor, we'll abide by that.
Well, the hope is that I'm going to cut and paste them, and it's hard to do with footnotes.
I understand. No problem.
So it's to your benefit. To that end, if the parties could please try to avoid rhetoric in the proposed findings of fact, conclusions of law. The idea and hope is that I'm going to use them, and if they're very argumentative, that's difficult to do. So if you can just lay out the case, the facts that you think have been established in the law that you think you have applied in a manner in which a court might rule, that would be the most helpful to me, especially given the limited time that I'm going to have between submission and November 17th, which is when the time will talk. The time will, when everyone's going to be required to be submitted under the 11113. And if you can, I'm not going to make page limitations, but I just request that people be judicious with likes so that I have time to actually process them, read any cases I haven't already read, etc., in the limited time between November 8th and November 17th. And then I just want to make sure, so first of all, Mr. Klarchuk, do you anticipate that the Secretary of State will be making any proposed findings? Okay. And will they just be on very discrete issues?
Your Honor, we haven't had a chance to fully confer with my client since we're concluding the hearing now, but I would anticipate proposed findings specifically around Ms. Rudy's testimony, documentation practices at the Secretary of State's office, and some of the legal issues that I think we've briefed previously.
Okay, so if you could just try to, that's fine. I just don't want a lot of duplication, but I understand that you're kind of a lone wolf in this process, and so if you can just do as everybody else does and try not to make them too long, that would be great.
I would wager, Your Honor, that mine will be substantially shorter than other parties in the case, but there are some important institutional interests that the Secretary of State wants to vindicate through this process.
Well, and I'm absolutely not, she's the respondent in the case, she obviously has the right to submit proposed findings, facts, conclusions of law, so.
Thank
Okay,
you.
and then can the Republican Party and President Trump coordinate and submit one set?
I think this will be the first time in history that President Trump and the Republican Party have stated in court that they will cooperate. But we will do that, of course.
Yes, we can do that.
Okay, great. So I will expect to see 3 submissions. No page limits, but just please don't go overboard.
Your Honor, would you like us to coordinate so that we have a unified submission on behalf of President Trump and the Colorado Republican Party?
Yeah, that's what I'd like, one submission, if possible. And then on the exhibits, you're going to have to submit all the exhibits that have been offered and not admitted. I'm not sure if there are any. But if you've offered them and I excluded them, they need to be submitted as that with cover pleading. And then if they've been offered and admitted, they need to be under separate pleading and they need to be submitted. And this is online, understanding that the videos are going to probably have to be, like a page, like video submitted to the clerk's office separately or something like that. But in order to have a clear record, you're going to have to do that on the judicial electronic filing system. And then I think the best thing to do is for the videos, if each side can submit the videos that were both admitted and offered and not admitted on like flash drives, so that the clerk's office, I believe, will accept that way. But showing them to me or handing them to me doesn't cut it and won't make it to Supreme Court if and when this gets appealed.
Just one question on that, Your Honor. It's a little complicated here because the anti-SLAPP motion we filed about there was sort of motion practice or the admission of evidence before it was officially offered in court. So for the exhibits offered but not admitted, just confirming for us that includes information that we tried to use on the anti-SLAPP motion that you then said you would not admit the evidence, or is it just what happened this week?
So I mean, did the anti-SLAPP motion include videos and stuff?
The anti-SLAPP motion, it referenced videos. I don't know that we included videos. Okay, yes, it did include videos.
Okay, so to the extent that those exhibits, the ones that you filed, that's fine. If part of the support for the anti-SLAPP motion was videos, then those should probably be submitted to the clerk's office as the videos in support of the anti-SLAPP motion. And then, in my view, this is totally different. And so, any exhibits or videos that were presented and admitted in this hearing need to be separately submitted.
Thank you, Your Honor. And then just on the transcripts, would you like the transcripts with the filings on Wednesday? I think we're going to receive the final ones on Monday. Would you like them on Monday, or want to wait when we submit our proposed findings that concludes law on Wednesday? Do you have a particular format that you prefer them?
No, I don't have a format, and I plan on spending Monday, Tuesday, Wednesday catching up on my other 199 cases and probably reading some of the case law and things that have been talked about during the course of the trial. So we'll have plenty to do.
Great. Thank you, Your Honor.
Anything from you, Mr. Kessler?
No, Your Honor.
Sorry, one last thing, Your Honor. I think we forget sometimes that the Secretary of State, Republican Party, are parties here. So on the closing arguments, I still assume 2 hours will be fine. But if we find out they have robust closing arguments, they also like to present the data.
I don't anticipate robust closing arguments, Your Honor. If they're mindful of the court's advisement that we are on the same clock in advance of the 15th, we will huddle internally and I'll confer with petitions if we want to take any of those in.
Okay, and why don't you, if you huddle and they say we really need the full hour and you need 20 minutes of your own, and that goes the same for the Colorado Republican Party. If you feel like you've got something that you need to say outside of what President Trump's saying and you need a little bit of extra time, just get in touch with us so that we can, we can start a half hour earlier if we need to. I don't want to deprive you of making your arguments.
Thank you.
Anything else that we need to address?
Not from us, Your Honor.
Well, I want to thank everyone that has been super helpful, and I really want to thank everybody that I appreciate the decorum that the parties have had throughout this entire proceedings. I know that This case, like all cases, but maybe particularly, is very deeply felt on both sides. And despite those deep feelings, I feel like the counsel for the parties has been very, very professional and has put on really outstanding presentation of the evidence and the arguments. So we will continue this hearing until either